Etwell.
Good morning, Commissioner.
How are you? Etwell, I'm joining with my computer as well. Can I switch off that? I'm switching off my iPhone to go to the computer.
That's fine. We can hear you clearly.
Okay, let me just check out of here.
I can hear you clearly.
You can hear me?
Yes, I can hear you.
Very good, because it's better that way. I'm on the computer. You can hear me and everything should be fine, right?
Yes, we should be okay. I think that should be okay.
Yes, I think so. There's an echo on your side. Is there an echo on my side as well?
No echo.
Okay, fine.
Thank you.
Thank you, Etwell.
Mic check 1 2. Mic check 1 2. Morning, Commissioner Topsisono. Can you hear me?
Morning, Etwell.
Good morning, Etwell.
How do you hear me?
Yes, I can hear you loud and clear.
Thank you very much.
Good morning, Etwell. How are you?
Good morning, Idrissa. Bonjour,
Good morning.
Idrissa, tu vas bien?
Oui, très bien, Ouvina. Ça va bien?
Ça va, on est les deux qui ne sont pas présents à Bonjour.
Oui, malheureusement, j'ai quelques contraintes qui m'ont empêché d'être présent physiquement, mais je suis depuis le début par visio.
Oui, oui, oui. On me dit.
Alors, tu fais aujourd'hui ta présentation, c'est ça?
Oui, je fais ma présentation aujourd'hui.
Très bien, donc je suis à l'écoute.
Merci beaucoup. Je sais que tu es toujours à l'écoute.
Voilà, bonne journée.
Merci, Idrissa.
Thank you.
Morning, Commissioner. So, we're just doing a test.
Okay, good morning as well. How is the session?
Well, it's going on fine. Thank you.
Okay, me, I'm following online.
All right. I hope you are able to follow without
Yeah,
any.
no problem. Everything is clear.
All right. Thank you very much.
You're welcome.
Idrissa, tu deviens bilingue toi aussi.
Bonjour, mesdames et messieurs. Je pense notamment aux participants. Prenez place. Nous allons commencer la session. Alors, sans plus tarder, je vous présente tout d'abord mes salutations à l'ensemble des participants. Pour la journée d'aujourd'hui, j'aurai le plaisir de présider la séance. D'ailleurs, aujourd'hui, demain et après-demain, le président ayant été retenu pour des obligations.
Kesho leo na kesho.
Je poursuis. Donc, pour la journée d'aujourd'hui, nous allons reprendre le point 5 relatif à la présentation et examen des rapports d'activité des membres de la commission et des mécanismes spéciaux. Nous aurons le plaisir d'avoir parmi nous, mais en virtuel, Madame la commissaire Topsisono, qui nous présentera son rapport. Suivra ensuite la pause café. Pour la matinée, nous continuerons le point 3 relatif à l'analyse de la situation des droits de l'homme en Afrique. Nous aurons la pause déjeuner comme d'habitude. Pour l'après-midi, nous allons accueillir le premier panel et lancement sur la sensibilisation aux lignes directrices sur la liberté d'association et de réunion en Afrique pour une mise en œuvre efficace. Suite à ce panel, nous aurons la présentation du rapport de Madame la commissaire Marie-Louise Abomo, rapport sur l'état des communications, et nous terminerons la journée en revenant au point 3 relatif à la situation des droits de l'homme en Afrique. Sans plus tarder, pour le point 5, nous allons avoir la commissaire Topsisono en ligne pour la présentation de son rapport en sa qualité de commissaire en charge de la liberté d'expression et d'information. Étoile, est-ce que Madame Topsisono est en ligne? Oui.
Merci, Madame la vice-présidente.
Bonjour, commissaire Topsisono.
Bonjour, vous allez bien?
Voilà, donc vous allez avoir 20 minutes pour la présentation de votre rapport. Suivront les différentes interventions des États qui auront 8 minutes, les organisations non gouvernementales et également les institutions nationales des droits de l'homme pour 5 minutes. Vous avez la parole, Madame Guérisha.
Thank you very much, Vice Chairperson. Good morning, Vice Chairperson, colleague commissioners, acting SCC, representative of state parties, CFOs, distinguished guests, and interpreters. My sincere apologies for not being present in Banjul, being retained by my professional commitments in my state country, Mauritius. My report covers activities carried out during the intersession period between November 2022 to April 2023. The present report details the activities undertaken in my capacity as a member of the Commission, a member of a working group on the death penalty, extrajudicial summary or arbitrary killings and enforced disappearances in Africa, the working group on death penalty, and as the special rapporteur on freedom of expression and access to information in Africa. The report is structured in 4 parts, namely, Part 1 will deal with activities undertaken in my capacity as member of the Commission and as member of a working group on the death penalty. Part 2 will state activities undertaken in my capacity as special rapporteur. Part 3, activities undertaken as country rapporteur. Part 4, report on interventions issued in response to human rights violations. And Part 5, as regards challenges and recommendations. So I go to Part 1 as activities in my capacity as member of the Commission. I participated in the 73rd Ordinary Public Session from 29th October to 9th of November 2022. Although the session was in person, I was unable to attend same physically due to work commitment in Mauritius, so I attended virtually. During the public session, in addition to other activities undertaken by the Commission, in which I participated, including a review of a state report of the Republic of Mauritania and Côte d'Ivoire. Subsequently, during the private session, I participated in the deliberations of the Commission, which yielded, amongst others, on decisions on communications resolutions on the renewal of mandate and reconstitution of 15 special mechanisms, including internal committees, country resolutions, and 5 thematic resolutions. On the 9th of January 2023, I participated in the Commission's 36th extraordinary session, which was held virtually. In line with the Commission's working methods, I participated in deliberations which produced, amongst others, the adoption of the 2022-23 Commission's work plan and resolutions. From the 21st of February to the 7th of March 2023, I participated in the Commission's 74th Ordinary Private Session, which was held virtually. I contributed to dialogue and arriving at decisions on communications, adoption of concluding observation on state reports, in addition to considering a number of reports and other outstanding matters. In the intersession period, I did not participate in any events involving the death penalty, extrajudicial, summary, or arbitrary killings, and enforced disappearance. We have, however, made several interventions which will be addressed further along in this report. As country rapporteur, I led the promotional visit to the United Republic of Tanzania from the 23rd to 28th of January 2023. Commissioner Lita Ogana was part of the mission, and as chairperson of a working group on indigenous population communities and minorities in Africa. During the mission, the delegation of the Commission met with state officials from relevant government ministries, relevant community leaders, civil society organizations, a cross-section of human rights actors in the country, as well as other individuals and institutions who enlightened us on the general human rights situation in the Republic of Tanzania, with a particular emphasis on indigenous populations. The main objective of the mission was to assess the human rights situation of indigenous populations, communities in Tanzania, including more particularly to review the situation in Ngorongoro Conservation Area, Loliondo, and Somera. Subsequent to the mission in February 2023, a delegation from the United Republic of Tanzania traveled to the Commission in Banjul to submit supplemental evidential documents in relation to the mission. All information and evidence that has been gathered is being considered at the moment, and this will lead towards the development of a report for adoption by the Commission. As for my activities undertaken as a special rapporteur, on the 10th of November 2022, I participated in a symposium on access to information. The symposium was collaboratively hosted by the University of Pretoria Center for Human Rights, the Independent Electoral Commission, the Information Regulator, and the South African Human Rights Commission, the Human Sciences Research Council, and the Media Monitoring Africa. The symposium followed a study on South Africa's compliance with the Commission's guidelines on access to information in Africa. It facilitated the implementation of the recommendations towards promoting transparent elections and improving access to information and elections in South Africa. It was an effort to advance a structured advocacy strategy for the consideration and implementation of the guidelines. On the 27th of November 2022, I virtually participated in a side event at the Internet Governance Forum, which took place in Addis Ababa. The event was hosted by the Association for Progressive Communicators. The event built on the recommendations of the 2021 report on freedom of expression and gender justice by the UN Special Rapporteur. I delivered an opening address and participated in deliberations to explore potential synergy and collaborative work for the future. On the 15th of December 2022, I delivered a keynote address at the Conference on the Future of Free Speech, which was convened by Justitia International in Copenhagen, Denmark. The conference marked the closing of the first phase of a Future of Free Speech project. It convened experts from technology companies, civil society, international organizations, and academia to discuss burning issues on the future of free speech, as well as the future of content moderation online, looking at global developments from around the globe. During the intersession period from the 1st to 3rd of February 2023, I led the Commission's delegation in hosting a regional seminar on freedom of expression and access to information in Africa. The seminar took place in Johannesburg, South Africa. The main aim of the seminar was to disseminate the 2019 Declaration of Principles on Freedom of Expression and Access to Information in Africa, as well as other soft law instruments on access to information in Africa. The seminar convened 53 delegates from government, NHRI, civil societies, and media practitioners in Lusophone countries. The seminar was a success, and we left with some very key recommendations and targeted strategies to advance the work of the mandate and to deepen engagement by various stakeholders with the principles of freedom of expression and access to information at heart. The main outcome of the seminar was an increased awareness, understanding, and commitment to and ownership of the 2019 declaration. The participants left with strengthened capacity for implementation at national level. From the 21st to 23rd February 2023, I attended and delivered a keynote address at the Internet for Trust Conference side event. The conference was in hybrid mode and I participated virtually. The focus of my intervention was on social media for peace. The side event provided us with the opportunity to share and exchange experiences of best practices. We took stock of key achievements and in the project on social media for peace, and we also discussed and conceptualized concrete strategies and actions for follow-up. On the 2nd of May 2023, I participated in the World Press Freedom Day at the UN in New York on the invitation of UNESCO for the launching of a joint declaration from the UN organization. And all the special rapporteurs, namely the UN agencies, the Organization for Security Cooperation in Europe, me representing the Commission, as well as the Inter-American Commission for Human Rights, have contributed towards the preparation of a joint declaration, which this year has as theme Media Freedom and Democracy. On the 1st of May 2023, all the special rapporteurs continued the work started at UNESCO headquarters in Paris on the means to regulate media platforms. I was not present in Paris on the 1st of May, and I was not in Paris in February 2022, but I was present virtually. In line with the special mechanism's mandate to make public interventions where violations of the rights to freedom of expression and access to information have been brought to the attention, including by issuing public statements, press releases, and sending appeals to member states asking for clarifications. This section of the report provides information on the interventions taken to address alleged violations. So in January 2023, I participated in a letter of joint concern to His Excellency Mr. Patrice Talon, President of the Republic of Benin, in response to the alleged extrajudicial executions by state agents in the Republic of Benin. We expressed concern over the recurrences of these incidents and the lack of response from the competent authorities, as well as the resulting serious violations of human rights in contravention of African Charter, more specifically Article 4. In the letter, we urge the state to proceed with impartial and independent judicial investigation, to determine the violations committed in the context of a reported incident, establish responsibilities, and bring the perpetrators to justice. In January 2023, I participated in a joint letter of appeal to His Excellency Paul Biya, President of the Republic of Cameroon, in response to the assassination of Mr. Mbani Zogo. In this regard, we urge the state to inform the Commission of the measures taken by the government to carry out rapid, independent, and impartial investigations on the facts, to establish responsibility and bring the alleged perpetrators to justice. We further urge the state to take appropriate measures to put an end to threats and reprisals against journalists and human rights defenders, and to guarantee in all circumstances the safety and protection of all persons residing in the country. In March 2023, I participated in a joint letter of appeal to His Excellency Mr. Hakainde Hichilema, President of the Republic of Zambia, in response to allegations reaching the Commission regarding the forced eviction of a Kasima community in Mangunu District, Zambia. In the letter, we expressed concern at the allegations and referred to Article 5 on the protection from inhuman treatment, Article 9 on the protection of freedom of expression, Article 10 on the freedom of assembly and association, 12 on the freedom of movement, 14 on the right to property, and 18 on the protection of the family, as well as Articles 21 and 22 on the right to people to enjoy natural resources and socio-economic developments. Amongst other things, we called on the state to provide urgent medical treatment, psychological and material support, and temporary alternative accommodation to displaced persons. We urge the state to review and, if proven unlawful, revoke the alienation of a communal land in Kasima and to allow the displaced persons to return to their land. Where restitution is not possible, we encourage the state of Zambia to provide alternative land and accommodation of equal value. On the 6th of April 2023, I participated in the joint urgent appeal regarding the alleged arbitrary detention of Mr. Abdallah Ahmed Mumin. We raised concerns that if the allegations were made to be true, the actions taken against Mr. Mumin suppress the right to freedom of expression, access to information, and media freedom, which the Federal Republic of Somalia is obliged to respect by virtue of the international human rights institutions to which the state of Somalia is signatory. Amongst other things, we requested the state party to provide the Commission with sufficient clarification regarding the above stated allegations, to investigate reasons for the arrest of Mr. Mumin on February 2023, and release him if the arrest was found to be arbitrary, to guarantee Mr. Mumin's right to legal representation and to be defended by counsel of his choice, to give due attention to Mr. Mumin's health and to provide him with access to health care, to respect his rights to freedom of expression and opinion and to disseminate them within the law, to eliminate the suppression of media practitioners and organizations. During this period, I have also jointly participated in the development of letters of recommendation to countries which have made strides towards the protection and promotion of human rights. There was a joint letter of commendation to Zambia in December 2022 in response to the Penal Code Amendment Act number 25 of 2022, which aims at abolishing the death penalty in the Republic of Zambia. In the letter, the Commission welcomed the fact that the measure to abolish the death penalty covers all crimes and was taken in conjunction with the abolition of the crime of defamation of a president. In this spirit, the Commission encouraged the government of the Republic of Zambia to pursue these efforts by ratifying the second optional protocol to the International Covenant on Civil and Political Rights on the abolition of the death penalty, and by supporting efforts towards the adoption of a draft protocol to the African Charter on the abolition of the death penalty in Africa, in order to strengthen the framework for the protection and promotion of human and people's rights in the Republic of Zambia. In response to this letter, we have received a response from His Excellency, which we will respond to in due course. In February 2023, I participated in a joint letter of commendation to His Excellency, the President of the Republic of Zambia, in response to the commutation of 390 death sentences to life imprisonment following the abolition of the death penalty. On 2nd of November 2022, I issued a press statement commemorating the International Day to End Impunity for Crimes Against Journalists. The theme of the day was Protecting Media to Protect Democracy. In the statement, which is published on the website of the Commission, I noted with concern the increasing trend of crimes against journalists going unpunished. Of great concern, I noted that whilst laws criminalizing journalistic works are proliferating, there is no corresponding enforcement of rights and laws meant to protect journalists. I called on states to comply with provisions of Article 9 of the Charter, as read together with Article 1, and specifically to investigate, prosecute, and punish perpetrators of attacks against journalists, to ensure that cases of attacks against journalists that have been pending, the prolonged periods of time that are handled fairly and effectively, to desist from weaponizing the law enforcement and the judiciary against journalists by limiting their access to justice, where there have been cases of attacks, to ensure that any law enforcement officials responsible for prolonged delays or ineffective service in cases relating to attacks against journalists are identified and punished accordingly, to promote the eradication of impunity for crimes against journalists, including by perpetrating a positive narrative on journalists. Finally, in 2022, I sent note thereby requesting authorization to undertake promotional missions in the Republic of Botswana, the Kingdom of Lesotho, the United Republic of Tanzania, and the Republic of Zambia. The Kingdom of Lesotho has granted the Commission access to undertake a promotional visit, which I intend to undertake during the intercession period. The mission will enable me to interact directly with the state party about the human rights situation generally. It is also an important opportunity to consider how Lesotho's protection and promotion of human rights can be supported and strengthened. Promotional visits are an important part of the Commission's promotional mandate. To this end, I accordingly encourage state parties to respond positively to requests for authorization to undertake promotional visits. The Declaration of 2019 reaffirms the fundamental importance of freedom of expression as an individual human right, as a cornerstone of democracy, and as a means of ensuring respect for all human rights and freedoms. While there is consensus that freedom of expression is a fundamental human right, it is equally important to note that this right is not very effective if there is no way for those who wish to access that information cannot obtain it. Through the mandate, I urge the state parties to ensure protection of freedom of expression, including through ensuring protection of journalists and media practitioners, and revising laws which impede the right of freedom of expression, in addition to consistently calling for adoption of access to information laws in the legislation, in accordance with regional and international standards as embodied in our model law. Accordingly, with regards to freedom of expression, I call on state parties to take the necessary measures to prevent attacks on journalists, and when they do occur, to investigate them, punish perpetrators, and to ensure that victims have access to effective remedies. Furthermore, I urge state parties to respond to letters of urgent appeals with the information requested and to take all appropriate action as recommended in letters. With regards to access to information, I would like to specifically call on states who have not adopted access to information laws to do so and to commit to the process of formulating an access to information law. I remain available to provide any technical assistance required by state parties during this process. Additionally, I note that adoption of an access to information law is only the first step. The laws need to be effectively implemented. Accordingly, I call on state parties who have adopted access to information laws to ensure that these laws are effectively implemented. Lastly, I would like to call on state parties who have not done so to ratify and domesticate the various instruments of the African Union which guarantee the right to access to information, such as the Convention on the Prevention and Combating Corruption, the African Youth Charter, and the African Charter on Elections, Democracy, and Governance. The ratification and domestication of these treaties, coupled with adoption and implementation of access to information laws, will contribute to the eradication of corruption, observance of human rights, and improvement of the quality of life on the African continent. Thank you for your attention. Thank you, Vice Chair. I hand over the floor to you.
Merci beaucoup, commissaire Vena Viry-Château-Psi-Sono. Merci pour la présentation excellente de votre rapport qui nous a permis effectivement d'avoir une vue d'ensemble sur les différentes activités menées pendant l'intercession. Nous allons passer donc au deuxième segment, toujours du point 5, c'est-à-dire les demandes de prise de parole autour de votre rapport. Alors, pour le moment, je n'ai pas de demande de prise de parole par les États. Je n'ai pas également de demande de prise de parole par les INDH. Je vois l'Algérie qui ne s'est pas inscrite, mais qui voudrait prendre la parole. Allez-y. Vous avez 8 minutes.
Thank you, Madam Vice Chair or Madam Chair. You are chairing the meeting. And good morning, good afternoon to everyone. First of all, I would like to thank the Special Rapporteur Psi-Sono for the presentation of her intercession report. We take note of the recommendations contained therein. And briefly, I have maybe a suggestion or a comment and then a question addressed to the Special Rapporteur. So we know that the Declaration of Principles on Freedom of Expression and Access of Information in Africa, adopted in 2019, replaced the one of 2002, and the new declaration now encompasses the issue of access to information. On the website of the Commission is not the current website is not really friendly user, so not easy to have access to the declarations of principles and the soft laws. So perhaps if there is some improvement to have a collection of the soft laws and declaration of principles, that would be helpful to all of us. So that was so my question to the Commissioner is how we, in her opinion, we can help to increase the awareness and understanding, and also the commitment and ownership to the Declaration of Principles that was adopted in 2019. Whether that would be in workshops, sub-regional workshops, or any kind of other means. So that's my question. Thank you.
Vice Chair, may I respond now or shall I wait for everything?
Je vais peut-être rebondir pour votre première observation concernant l'absence de la déclaration sur le site de la Commission. Alors, il me semble que, en général, lorsque les textes sont adoptés par les différents commissaires, il faut également rechercher les activités par commissaire. Et là, vous pouvez trouver les textes adoptés dans le cadre de leur mandat, éventuellement. Alors, je vais passer la parole. Il n'y a pas d'autres prises de parole par les États, pas d'INDH également. Par contre, nous avons 3 demandes de prise de parole par les organisations non gouvernementales. Alors, je vais tout d'abord passer la parole à l'ONG Rencontre africaine pour la défense des droits de l'homme, la RADDHO, Monsieur Ibrahima Mbodj. Est-ce que vous êtes dans la salle? Oui. Vous êtes là? La RADDHO. Il arrive. D'accord. Oui. D'accord. Sinon, on va... Il arrive, d'accord. On va l'attendre. It's physical. C'est ma voix. D'accord. Allez-y, installez-vous, prenez une place. Vous pouvez avoir un micro. Oui. Allez-y, vous avez 5 minutes. Marche pas. Changez de place. Cinq minutes, votre déclaration et vos questions. Allez-y.
Merci de m'avoir donné la parole. Un honneur et un plaisir d'être devant vous aujourd'hui. J'en profite pour vous réitérer mes remerciements, mes hommages, mais aussi ma gratitude pour m'avoir donné cette opportunité. Et je rends hommage aussi à la Commission africaine pour le travail énorme qu'elle fait sur le continent. Ma présentation va se porter sur la liberté de presse au Sénégal, dans le cadre de la RADDHO, avec comme structuration en 2 points. Le premier point va porter sur le paysage médiatique de la liberté de la presse au Sénégal. Le second point va porter sur les atteintes à la liberté de la presse. S'agissant du premier point, le paysage médiatique au Sénégal. Notez, madame et monsieur, que le paysage médiatique sénégalais est large et diversifié. Il existe 28 chaînes TNT avec des orientations généralistes, religieuses et culturelles. Au niveau de la presse écrite, on note 45 titres avec un tirage de 250 000 exemplaires par jour. Au niveau des radios aussi, on dénombre 200 stations radio. Parmi ces stations radio, il y a une 50aine de stations de radio commerciales qui partagent des informations, des divertissements et proposent des espaces publicitaires pour les entreprises locales et nationales. En fait aussi, la presse en ligne dépendante, tout ce qui est disponible, 200 presse en ligne, qui diversifient les sources d'informations pour les utilisateurs. Mais, madame et messieurs, malgré ce paysage médiatique riche et diversifié, force est de constater que la liberté d'expression de la presse au Sénégal connaît des de télévision. Au niveau de la presse a été facilité par le code de la presse et le code pénal qui prévoit des peines d'emprisonnement, de diffamation et d'offense au chef de l'État. Donc, il n'est pas étonnant, voire anodin de voir le Sénégal régresser au niveau du dernier classement annuel de Reporters sans frontières, perdant 31 places, passant de la 73e place à la 104e place mondiale, ce qui est effarant et inadmissible. D'ailleurs, parmi les journalistes ou bien les hommes de presse qui ont eu à subir les foudres de ce code pénal, on peut citer quelques exemples, notamment l'exemple du journaliste Adam Gueye, qui est un ancien directeur de la communication CDAO, qui a été arrêté à Dakar le 29 juillet 2019 à 5h45 du matin suite à un article qu'il venait de poster sur sa page Facebook consacrée au pillage des hydrocarbures au Sénégal. On peut aussi prendre l'exemple de Pape Alignon, qui est certainement, son cas est certainement plus célèbre, qui est un journaliste d'investigation du site d'information Dakar Matin, arrêté le 9 novembre 2022 et inculpé de divulgation d'informations de nature à nuire à la défense nationale. La liste ne s'arrête pas là. Il y a aussi le cas du journaliste Pam Ndiaye, journaliste de Wolf TV, arrêté et inculpé pour les chefs d'accusation suivantes: provocation d'un attroupement, outrage à magistrat, intimidation et représailles contre membres de la justice, discours portant sur discrédit, sur un acte juridictionnel, diffusion de fausses nouvelles, mise en danger de la vie d'autrui. Il y a aussi l'exemple de Babacar Touré, convoqué à la division des investigations criminelles, DIC, suite à la plainte d'un policier qui l'accuse d'outrage à agent. À la suite de sa convocation, M. Touré, patron du site d'information Kewulo, est placé en garde à vue. 7 chefs d'accusation sont retenus contre Babacar Touré, notamment faux usage de faux, diffusion de fausses nouvelles, diffamation, injure publique, dénonciation calomnieuse. Mesdames et messieurs, voici la triste réalité de la liberté d'expression au Sénégal qui est en train d'être muselée. Je vous remercie de votre attention. Merci.
Merci beaucoup aux représentants de la radio. Je pense que la commissaire Vina Petit-Sono a dû prendre l'autre et elle interviendra pour la suite. Deuxième intervenant, il s'agit de Zimbabwe Lawyers for Human Rights, Monsieur Tinomudat Chopo, Monsieur ou Madame, normalement présent dans la salle. Zimbabwe Lawyers for Human Rights. Vous êtes là? Allez-y, vous avez 5 minutes. Allez-y, Monsieur Chopo.
Honorable Chairperson, Honorable Commissioners, States Delegates, ladies and gentlemen, Zimbabwe Lawyers for Human Rights presents this statement on freedom of expression in Zimbabwe. Zimbabwe Lawyers for Human Rights has been engaging this Honorable Commission formally for at least 18 years. We take this forum and our mandate to promote and protect human rights in Zimbabwe seriously. The information we present is based on cases we litigate and HRDs that we represent. We welcome the opportunity to share our comprehensive documentation with this Honorable Commission. Even the Honorable State Representative who replied to our HRD statement has benefited from our protective legal services in March 2013 when he was arrested. Since the 24th ordinary session in October 2022, the government of Zimbabwe has failed to take meaningful steps towards upholding freedom of expression. The government of Zimbabwe has been unrelenting in its censure of civil society organizations, human rights defenders, and dissenting voices who have been subjected to unwarranted and intemperate hate speech online and in the state media. Although there was a meeting between civil society and the president over the PVO bill, nothing has come out of this meeting yet, and we still wait. If the PVO bill is passed in its current form, it includes vague and wide provisions relating to political lobbying, which can potentially be abused to stifle legitimate freedom of expression by civic society organizations. The repressive provisions of the Criminal Law Codification and Reform Act continue to be selectively applied, undermining the freedom of expression. Zimbabwe Lawyers for Human Rights has represented people charged with violating sections 31 and 33 of the Criminal Law Code, which provides for offenses of communicating or publishing falsehoods and undermining and or insulting the president respectively to curtail freedom of expression. Some have been convicted and some have filed appeals against the convictions. Opposition party national spokesperson and lawyer Fadzai Mahere was convicted and sentenced for the criminal offense of publishing or communicating falsehoods in terms of section 31 of the Criminal Law Code over tweets which she posted in January 2022 concerning police brutality. Further, a religious leader, Parare Kanyenzura, was convicted of convening a public gathering without notifying the police after he led a procession singing "God Save Us, we have suffered enough." And opposition political leader Jacob Ngaruvume was on 27 April 2023 convicted of inciting public violence for calling for peaceful anti-corruption demonstrations. Students' rights to expression and academic freedom are also being impeded by the invocation of the offense of disorderly conduct in order to stifle legitimate students' concerns and activities. Furthermore, the gazetting of the Criminal Law Codification and Reform Act Amendment Bill, which contains clauses creating a new criminal offense of willfully damaging the sovereignty and national interests of Zimbabwe in respect of Zimbabwean citizens or permanent residents who meet with foreign governments with stiff and unconstitutional penalties ranging from imprisonment, deprivation of citizenship, prohibition from voting, and prohibition from holding public office. If passed into law, these amendments will also affect civil society organizations and individuals involved in human rights, rule of law, and governance issues. Provisions of the Postal and Telecommunications Act and the Data Protection Act are also being applied to stifle dissenting voices. Tafazwa Jaji, a student activist, was arrested and charged with contravening the Data Protection Act for allegedly posting a WhatsApp message complaining about the conduct of ZANU-PF. Attacks on journalists demonstrate an escalating affront to freedom of expression. Following the expose by the Al Jazeera's investigative unit on corruption, gold smuggling, and money laundering, the presidential spokesperson threatened the journalists who were covering the document with imprisonment on his Twitter handle. In light of these concerns, the Zimbabwe Lawyers for Human Rights calls upon the African Commission on Human and People's Rights to urge the government of Zimbabwe to, number one, take progressive measures to guarantee the safety and security of journalists, whistleblowers, and all media practitioners. Two, uphold the freedom of expression by welcoming the free flow of information, artistic expression, and varying opinions. Three, repeal restrictive and draconian legislative and institutional frameworks which are used to take down free expression. Four, desist from making unwarranted and disparaging attacks on civil society organizations online and in the state media. Five, abandon or amend the provisions of the Criminal Law Codification and Reform Act Amendment Bill, relating to the criminal offenses for the supposed unpatriotic act. And lastly, abandon or amend the provisions of the Private Voluntary Organizations Bill. Thank you.
C'est Open Society, Brahim Beldi, c'est bien ça? Madame la Présidente, honorable commissaire, mesdames, messieurs, il s'agit dans cette intervention de faire des éclaircissements sur la situation du droit de liberté d'expression en Tunisie. Alors, à l'instar de presque tous les droits de l'homme, la régression et la tendance du droit de liberté d'expression en Tunisie, juste après le changement constitutionnel du pouvoir du 25 juillet 2021, les autorités en place ont instrumentalisé le tribunal militaire pour y traduire des opposants et activistes de droits de l'homme pour avoir exprimé leur avis. Le cas le plus spectaculaire fut celui de l'ex-bâtonnier Abdelrazak Kilani, traduit devant l'instruction militaire, puis arrêté un mois pour avoir rappelé aux policiers leur devoir d'impartialité et le respect de la Constitution. Son affaire traîne toujours devant le tribunal militaire. Le député aussi et avocat avec Chebi a été condamné pour un an de prison ferme pour par le tribunal militaire pour atteinte à l'armée et sa réputation suite à des déclarations dans les médias, mais la répression touchait petit à petit un public plus large, ainsi des dizaines de jeunes internautes ont été traduits devant le tribunal militaire à Tunis, de la capitale, aussi par exemple le tribunal d'Alquerque, qui a condamné pour un an de prison ferme un jeune internaute pour des publications anti-Kais Saïed, le président, donc considéré comme une atteinte à l'armée et sa réputation. Après les vives critiques internes et internationales, le pouvoir a changé son modus operandi. Il faut rappeler que depuis le coup d'État en juillet 2021, Kais Saïed est le seul déteneur de tous les pouvoirs exécutifs et législatifs, sans aucun pouvoir ni recours contre ces décisions. Pour consacrer son hégémonie absolue, il a édité le décret 117 qui lui permet de légiférer par décret supra-constitutionnel dans tous les domaines. Il est toujours opportun de rappeler aussi que la Cour africaine des droits de l'homme et des peuples a condamné à juste titre le changement constitutionnel du pouvoir et a notamment ordonné l'annulation du décret 117. Donc, c'est à la base de ce décret que le président a décrété un décret 54-2021 qui a pour titre la lutte contre les infractions se rapportant au système d'information et communication et qui contient, entre autres, un article 25-24 censé protéger contre les rumeurs et les fausses nouvelles dans les médias ou réseaux sociaux avec ces peines disproportionnées, en l'occurrence 5 ans de prison ferme et 50 000 dinars d'amende, et les peines sont doublées s'il s'agit d'un agent public ou assimilé, c'est-à-dire 10 ans de prison ferme pour un statut Facebook par exemple, tout ça avec une rédaction juridique ample et inadéquate avec un texte commun. La société civile tunisienne, bien sûr, n'a pas tardé à exprimer ses soupçons quant à l'instrumentalisation de ce texte comme un outil de répression pour museler tout avis dissident. Les autorités en place ont prouvé que cette crainte de la société civile était bien fondée. En effet, le président Kais Saïed s'est muni non seulement d'un texte de loi pour base de représailles contre tout avis dissident, mais il a mis aussi les mains sur la justice. Aussi, il procède à la dissolution du Conseil supérieur des magistrats élus et désigner un nouveau à sa guise et décréter même un texte lui permettant de limoger tout magistrat sans procédure disciplinaire préalable. Et il ne s'est pas privé de l'usage de cette prérogative durant 57 jours, et même ceux qui ont des arrêts de sursis d'exécution du tribunal administratif ne sont pas réintégrés jusqu'à aujourd'hui, ce qui bien sûr rend les autres juges dociles et garantit une obéissance à l'exécutif. Ainsi, on a pu documenter des centaines de traductions devant les tribunaux et les juges d'instruction sur la base de ce décret 54 et traduit tout genre des partis politiques, comme c'était le cas notamment pour Shaima Issa, Razi Shaweshi, Mobile Khiri, Lazar Akermi, des activistes des droits de l'homme, c'était le cas notamment avec Ayeshi Hamani, des Agrouba et des syndicalistes comme Moji Zidi, des anciens membres de l'instance supérieure des élections comme Semi Ben Slem, Zeki Rahmoudi, et même des journalistes passibles normalement à la base du décret 115 relatif aux crimes commis par les journalistes, et est un texte spécial qui évince normalement l'application de ce décret 54, sont aussi traduits à la base de ce décret liberticide, comme les journalistes Monia Arfel, Mohamed Bougaleb, Nizar Behlou, et beaucoup de jeunes internautes aussi, comme c'est le cas de Hamza Labidi, l'étudiant Baha Eddin, Hamda et bien d'autres. Il est important de mentionner que le ministre de la Justice et quelques ministres aussi ont été l'origine de demandes de traduction sur la base de ce décret 54, dont l'usage a un sens unique. Seuls les opposants au président Kais Saïed sont traduits. Ses supporters leur est permis, leur crime au sens du décret 54 reste impuni, même si les faits sont beaucoup plus graves que ceux des opposants à Kais Saïed qui sont traduits. Honorable commissaire, il est évident que ces pratiques des autorités en place ne présagent rien de bon pour l'avenir de la liberté de presse en Tunisie. Leur condamnation nous semble indispensable pour étayer les efforts de la société civile tunisienne pour préserver l'étroite marge de liberté d'expression qui reste et qui est de plus en plus durement réprimée, et je vous remercie.
Merci beaucoup. Je vais donner la parole au professeur nous avons une demande de prise de parole avec le représentant de Singapour. Excellence, vous avez la parole.
Thank you very much. Good morning, everyone. Your Excellencies, we have an unprecedented situation here where there is a single CSO that has presented 3 times. The Zimbabwe Law for Human Rights made their 3rd presentation today on largely same issues. It is as if they don't trust you. So they repeat it the second time. And when they feel they have come we will not
Vice Chair. Vice Chair. Vice Chair. Thank you, Vice Chair. So I would like to thank all those who have intervened, and namely from Algeria, Senegal, Zimbabwe, Tunisia, and Zimbabwe again. We've taken on note whatever they have stated, but would wish to have a copy of their statements, and also would like to ask all the NGOs to send to the Commission all violations or alleged violations involving violations of freedom of expression and access to information, so that my mechanism is aware of same and can consider interventions. Also, as to the first intervener, the gentleman from Algeria, I will make sure that he gets a link to the soft copy of the 2019 declaration and the soft laws in relation to access to information and the freedom of expression. As to the increased awareness of the 2019 declaration, the Commission is considering having workshops in Northern Africa, and we will see whether it will be virtual or physical. As regards the other interveners, if we could have a copy of their statements so that in fact we can the mechanism can consider whether it will intervene. And I would wish to thank them all for their interventions and for making the mechanism aware of the situation in the various countries. Thank you.
Revenu dans une demi-heure pour réagir sur le point 3, c'est-à-dire la situation de l'Europe en Afrique. Nous avons la possibilité de se donner rendez-vous dans 30 minutes. Merci. situation des droits de l'homme en Afrique. Nous n'avons pas de demande de prise de parole concernant les États. Par contre, nous avons une organisation internationale qui voudrait prendre la parole virtuellement. Et toi, on va la voir peut-être en ligne. Il s'agit du bureau de liaison de l'Union africaine concernant UN Women. Est-ce que UN Women et le Liaison Office est en ligne? Ça doit être Madame, je pense, ou Monsieur Tiki Kel Alemou. Est-ce qu'il est en ligne ou elle est en ligne? Non? Et toi? Non. Peut-être qu'elle reviendra. Alors, je passe aux institutions nationales des droits de l'homme, INDH. Nous avons également une liste d'INDH pour intervenir sur ce point 3. Alors, nous allons appeler la CNDH du Mali, le Conseil ou la Commission des droits de l'homme du Mali, M. Agibou Bouaré, qui en est le président. Est-ce qu'il est en ligne? M. Agibou Bouaré, président de l'INDH du Mali. Non. Alors, je vais également appeler la Commission des droits de l'homme et de la bonne gouvernance de la Tanzanie. Alors, c'est monsieur, je pense, Madame Justice Mathieu Moïno. Donc, Commission des droits de l'homme et de la bonne gouvernance de la Tanzanie. Est-ce que la personne est en ligne? Non. Ensuite, nous avons la Commission nationale des droits de l'homme du Kenya, Mademoiselle Roselyne Odede, qui est la présidente. Est-ce qu'elle est en ligne? Non plus. Ensuite, nous avons la Commission nationale des droits de l'homme du Togo, Fousseni Tabiratou. La Commission nationale des droits de l'homme du Togo, dans la personne de Fousseni Tabiratou. Est-ce que la personne est en ligne? Non. Alors, nous allons passer aux organisations non gouvernementales et j'ai sur ma liste, sauf s'il y a, pardon, merci. Alors, je vais revenir sur les organes de l'Union africaine et un mandat des droits de l'homme pour rappeler African Union Commission Office of Youth Envoy, envoyé spécial des jeunes. Etumba Smith. Est-ce qu'elle est en ligne? Je pense que c'est une demoiselle. L'envoyé spécial de l'Union africaine pour la jeunesse. Non. On verra par la suite. Donc, je reviens à la liste des organisations non gouvernementales et j'ai sur ma liste Under the Same Sun Fund, Tanzania. Mawe Wame Daklo. Est-ce que vous êtes en ligne?
Yes.
Allez-y, vous avez la parole. Allez-y.
Statement delivered by Africa Albinism Network on behalf of Under the Same Sun on the human rights situation of persons with albinism in Africa. The Africa Albinism Network, speaking on behalf of Under the Same Sun and over 200 groups, albinism groups across Africa, draws your attention to the ongoing cases of physical attacks against persons with albinism. In our region, there are over 900 cases of attacks reported to date. We believe that many more cases go unreported due to the frequent involvement of family members. This is disturbing because people with albinism are very few and very visible. In the last 2 years, 47 cases of attacks have been reported in 12 countries across Africa. These include killings and trafficking in person and body parts. Unfortunately, Madagascar and Zambia are leading in this period with 15 and 8 cases, respectively. We note and welcome the recent adopted guidelines of the Pan-African Parliament to address accusations of witchcraft and ritual attacks as harmful practices. This is a significant step towards addressing the violence faced by persons with albinism on the continent. We call upon member states to implement these guidelines and ratify the Africa Disability Protocol, which sets the general standards against harmful practices affecting people with disabilities, including people with albinism. To put a permanent end to the attacks targeting people with albinism, we call on member states to immediately implement the Africa Union Plan of Action on Albinism through national action plans on albinism that include protection measures. We congratulate those who have already done so or are on their way to doing so, such as Uganda, Kenya, and Tanzania. Finally, through national action plans, member states should also invest in measures to include people with albinism in the health system to prevent the alarming rate at which persons with albinism die of skin cancer due to exclusion and discrimination in health system, as well as due to climate change. Thank you.
Merci beaucoup pour votre présentation. Alors, en ce qui concerne la question de la protection des personnes albinistes, qui souffrent d'albinisme, justement, alors nous avons la commissaire, Madame Marie-Louise Abomo, qui a le mandat de protection pour les personnes âgées, les personnes handicapées, et son mandat couvre également la question de l'albinisme. Donc, si vous avez quelques informations supplémentaires, vous pouvez vous rapprocher de la commissaire Marie-Louise Abomo. Merci. Sans plus tarder, nous allons passer la parole à Paradigm Initiative for Information Technology Development. C'est monsieur, madame Tobekil Matimbe. Est-ce qu'ils sont en ligne? Oui, vous avez la parole.
Yes, I am. All right, thank you so much. Honorable Chairperson of the African Commission on Human and People's Rights, Special Rapporteur on Freedom of Expression and Access to Information, and Commissioners of the African Commission, Paradigm Initiative continues to echo its concern on the incidence of internet shutdowns in Africa, as highlighted at the 73rd Ordinary Session of this Commission. Due to ongoing occurrences, drawing the attention of the Commission to this crackdown on freedom of expression and access to information, as entrenched in Article 9 of the African Charter, PIN recently published the State of Digital Rights and Inclusion in Africa report, LONDA 2022, which focused on 24 African countries in Africa, and countries like Zimbabwe and Sudan featured with cases of internet disruptions in 2022. Several elections are expected in 2023, with Zimbabwe, which blatantly shut down the internet in 2019 and disrupted it in 2022, expected to hold its presidential election, and Sierra Leone, which has done so in the past as recorded by Access Now, is also planning for elections. Mali and the Democratic Republic of Congo are also expected to hold elections in 2023 and have a similar history of disrupting internet access. Paradigm Initiative is cognizant that such practices to disrupt the internet are an affront to their core obligations under the African Charter and their constitutions to respect and promote freedom of expression and access to information. Sudan, which also has a past history of shutting down the internet, is currently at risk of losing internet connectivity, as reported that due to power cuts. Amidst the ongoing conflict in the country, internet connectivity is very low. There is an urgent need for a speedy solution that ensures the restoration of internet connectivity in the country to ensure access to information in the ongoing situation. With regards to all upcoming elections in Africa in 2023, there's a need for African states to draw lessons from other African countries like Kenya in as far as keeping internet access open during such a critical time when access to information is a core ingredient towards free and fair elections. In addition, Paradigm Initiative recently convened the Digital Rights and Inclusion Forum, DRIF, hosting over 300 delegates in person in Nairobi, Kenya from 12 to 14 April. The forum convened digital rights actors from 35 African countries who echoed the need for an open and secure internet in Africa. It is also critical to highlight the need for some African states to desist from targeting the media as they conduct their mandate for ensuring information is accessed without frontiers through arbitrary arrests and harassment. Against this background, Paradigm Initiative urges the African Commission to call on the relevant African states holding elections, as mentioned in the statement in 2023, to refrain from shutting down the internet ensuring open and secure internet access. Furthermore, to also call on African states to review their record of protecting media freedoms and ensure a safe online space for the media to deliver on their mandate. And finally, also, we urge the Commission to consider participation in the Digital Rights and Inclusion Forum to interact with key digital rights stakeholders, advancing freedom of expression and access to information in Africa. Thank you so much.
Merci beaucoup, Madame Timbe. Nous avons pris note de vos recommandations. Et je pense que vous avez dû suivre précédemment la présentation du rapport de la commissaire Topsy-Sonneau sur la liberté d'expression et d'information. Ceci dit, si vous avez des informations supplémentaires, vous pouvez les transmettre à Madame la commissaire Topsy-Sonneau. Nous avons sur notre liste environnement, ressources naturelles et développement. Monsieur Bantou Balouti, en ligne. Est-ce qu'il est présent? Non. Je crois que nous n'avons plus d'orateurs en ce qui concerne la situation des droits de l'homme. Je me tourne vers Étoile si jamais d'autres intervenants voulaient prendre la parole. Étoile, il n'y a personne en ligne. Non. Très bien. Donc, nous allons clôturer ce point pour revenir au point 5 relatif à la présentation des rapports d'activité des membres de la commission et des mécanismes spéciaux. Nous avons le plaisir et l'honneur d'avoir Madame Marie-Louise Abonneau qui va nous présenter son rapport d'activité d'intercession du groupe de travail sur les communications. Madame Abonneau, vous avez la parole pour 20 minutes. Merci de me passer la parole, Madame la Présidente. Je présente mes respects aux distingués participants. Compte tenu du temps qui m'est imparti, je vais aller directement, je vais aller droit au but. Le rapport que je présente, conformément aux règles 25, alinéa 3 et 64 du règlement intérieur de 2020, est composé de 4 parties. La première partie va relater les activités du groupe de travail. La deuxième partie va évoquer les communications examinées au cours de la période couverte par le rapport. La troisième partie va évoquer les communications pendantes et la dernière partie sera réservée aux défis, recommandations et perspectives. S'agissant donc des activités du groupe de travail sur les communications, le groupe de travail s'est réuni virtuellement le 23 février 2023 et le 1er mars 2023. Au cours de ces réunions, le groupe de travail a examiné ce qui suit. Premièrement, les projets de décision sur l'admission des plaintes déposées. Ensuite, les communications susceptibles d'être transférées à la Cour africaine des droits de l'homme et des peuples. Ensuite, la proposition de mise en place du régime transitoire d'aide judiciaire de la communication. La proposition de critères relatifs au traitement et à la programmation des communications. Le rapport préliminaire sur l'état d'avancement de la mise en place du registre physique, y compris l'état des affaires égyptiennes, et le rapport d'audit des communications, le rapport des plaintes admises administrativement, conformément aux dispositions du règlement intérieur, la question des décisions rendues par défaut sur la possibilité d'opposition de la part de la partie défaillante. Le rapport de ces 2 réunions du groupe de travail a été adopté par la Commission lors de la session plénière de la 74e session ordinaire qui s'est tenue. La deuxième réunion du groupe de travail, qui devait se tenir avant la 75e session ordinaire, a été reportée pour se tenir en marge de celle-ci. S'agissant des communications examinées au cours de la période couverte par le rapport, le groupe de travail rappelle qu'à la 74e session ordinaire, il y avait 204 communications. Au cours de la 74e session ordinaire, la Commission a statué et a examiné et statué sur 22 communications, à savoir 4 communications sur le fond, qui ont été conclues, 5 communications sur la recevabilité qui ont été déclarées recevables, 5 communications qui ont été déclarées irrecevables et 8 communications qui ont été radiées du rôle. Le groupe de travail note qu'à la fin de la 74e session ordinaire, 187 communications étaient donc encore pendantes. Entre la fin de la 74e session ordinaire et le début de la 75e, 6 nouvelles plaintes ont été examinées administrativement pour l'admission, y compris une avec des demandes de mesures provisoires. 5 des plaintes ont été admises et la 6e a été rejetée. Par ailleurs, le secrétariat a reçu une demande d'avis consultatif remise par un individu. Cette demande a été rejetée de plein parce qu'en vertu de l'article 45 alinéa 3 de la Charte, seul un État partie, une institution de l'Organisation de l'Unité africaine ou une organisation africaine reconnue par l'Union africaine peut demander un avis consultatif à la Commission. Je passe maintenant aux communications en instance devant la Commission. Le groupe de travail constate qu'en ajoutant les 5 communications admises après la 74e session ordinaire aux 187 communications qui étaient pendantes à la fin de cette session ordinaire, le nombre de communications pendantes réduit de 192. Cependant, après la centralisation des communications et de l'audit inhérent à la matrice des communications, il s'est avéré qu'en réalité, le nombre de communications pendantes est de 197 communications. Il s'est agi d'un comptage physique. Alors, nous avons donc 43 communications au fond, 150 et une au stade de la recevabilité, une demande de révision, 3 communications en cours de préparation pour l'admission. En ce qui concerne les communications soumises par les États parties, la situation n'a pas changé par rapport au précédent rapport d'intercession. Par conséquent, aucune communication interétatique n'est en instance devant la Commission. Alors, quant aux défis, recommandations, perspectives, il faut dire qu'avec le recrutement d'un juriste arabophone en décembre 2022 et des traducteurs-interprètes pour les langues arabes, françaises et portugaises en avril de cette année, il y a eu une amélioration des ressources humaines disponibles au niveau du secrétariat, ce qui devra avoir un impact positif sur le travail de la Commission. S'agissant particulièrement des communications en arabe, le groupe de travail estime qu'avec le recrutement d'un juriste arabophone ou d'un traducteur-interprète arabophone, il sera possible d'accélérer le traitement des communications en langue arabe qui ont connu une certaine lenteur en raison de l'absence d'un tel traducteur permanent et d'un juriste pour traiter les dites plaintes. Cependant, malgré les améliorations constatées, les défis liés aux fonds limités qui sont alloués à la traduction de communications et des soumissions des parties, en particulier de et vers l'arabe, et où la plupart des communications sont en anglais et doivent donc être traduites en arabe, ces défis, disais-je, persisteront à moyen terme en raison de l'arriéré des documents à traduire. Par ailleurs, le non-respect par les parties des délais prévus par le règlement intérieur de la Commission et le faible taux de mise en œuvre des décisions de la Commission persistent. Au titre des recommandations, le groupe de travail exhorte les États parties à mettre en œuvre les décisions de la Commission et à l'informer de toutes les mesures prises ou en cours d'adoption pour mettre en œuvre les décisions les concernant dans le délai de 180 jours prévu à l'article 112 alinéa 2 du règlement intérieur de 2010 et l'article 125 alinéa 1er du règlement intérieur de 2020. Le groupe demande également à nouveau à toutes les parties aux communications d'appliquer les dispositions pertinentes du règlement intérieur, notamment en ce qui concerne les délais de présentation des arguments et de preuves aux différents stades de la procédure. Le groupe encourage les parties à utiliser les formulaires de plainte standardisés disponibles sur les sites Internet de la Commission. Vous les verrez. Le groupe renvoie les parties aux directives pratiques sur la portée temporelle du règlement de procédure tant qu'elles ne sont pas modifiées. Les dites directives pratiques peuvent être également consultées sur les sites Internet de la Commission vous verrez dans le rapport lorsqu'il sera publié. Le groupe de travail est convaincu que sa création était essentielle pour garantir un traitement rationalisé et plus efficace des communications. Toutefois, la réalisation de cet objectif continue de dépendre de la collaboration de tous les acteurs concernés au niveau régional et national. Le groupe de travail estime que la complémentarité entre la Commission et la Cour africaine est un mécanisme important de renforcement de la protection des droits de l'homme en Afrique. À ce propos, la Commission a chargé le secrétariat de traiter du transfert de 2 affaires à la dite Cour et encourage les parties à coopérer avec la Commission à cet égard. Le groupe de travail encourage le secrétariat à continuer à travailler à l'achèvement de la mise en place du système transitoire d'assistance juridique de la communication, ainsi qu'à l'amendement des directives pratiques pour créer un mécanisme de décision de défaut, un mécanisme de défense qui rendra le processus devant la Commission plus équilibré. Le groupe de travail est par ailleurs prêt à coopérer avec les hautes juridictions des États parties, les barreaux nationaux, les institutions de recherche, les universités, dans la diffusion et la vulgarisation de la jurisprudence de la Commission, ainsi que de la procédure en matière de protection des droits de l'homme et des peuples. Le groupe de travail continue donc de recueillir des propositions et des recommandations diverses auprès de toutes les parties prenantes en vue de renforcer l'accomplissement de son mandat et par extension, de renforcer le mandat de la Commission qui lui a été confié par les États parties. Mesdames et messieurs, je ne saurais terminer mon propos sans féliciter Pedro Rosa, le fonctionnaire juriste qui est le chef d'unité de traitement des communications, ainsi que toute son équipe, pour le travail remarquable accompli depuis sa prise de fonction. Je vous remercie de votre bienveillante attention. Merci beaucoup, Madame l'honorable commissaire Marie-Louise Abonneau, d'avoir présenté cet état des lieux du travail accompli par le groupe de travail sur les communications qui sont présentées à la Commission. Nous n'avons pas de liste d'orateurs susceptibles d'intervenir, mais je vais quand même, bien sûr, donner la parole aux États qui voudraient bien poser des questions ou apporter également quelques réflexions autour de ce mandat important attribué à la Commission africaine des droits de l'homme et des peuples dans le cadre de l'article 45 alinéa 2, qui est celui, effectivement, le mandat de protection relative aux communications. Alors, je vois qu'il y a une prise de parole demandée par l'Algérie et ensuite, ce sera la République du Cameroun. L'Algérie, vous avez la parole.
Merci, Madame la Vice-présidente. Bonjour à tous. La délégation remercie Madame la Commissaire, l'honorable Marie-Louise Abonneau, pour la présentation de ce rapport. Malheureusement, la délégation algérienne n'a pas pu accéder à la version écrite de ce rapport avant son examen au niveau de la Commission. Nous aimerions donc savoir s'il s'agit d'une pratique observée au niveau de la Commission compte tenu peut-être du caractère confidentiel des informations contenues du rapport, ou bien c'est un problème technique ou une anomalie qu'il conviendrait de rectifier à l'avenir. Je vous remercie.
Merci beaucoup. On vous apportera la réponse. Vous n'avez pas... Est-ce que vous pouvez répéter? Il y avait, je crois, un double son.
Pas de souci. C'est mieux comme ça? Il y a toujours un écho? Si je m'éloigne un petit peu. J'espère que ça va mieux comme ça. Je me suis éloigné un peu du micro.
Oui, mais commissaire Berceau, il s'agit tout simplement d'une demande de la commissaire Abomo, de la délégation nigérienne, de pouvoir répéter la même question. Donc, ce n'est pas une deuxième question supplémentaire. C'est la même question qui a été posée en premier lieu, mais la commissaire Abomo n'avait pas compris. Donc, je pense que, d'ailleurs, elle avait demandé à ce qu'il n'y ait pas l'utilisation du micro. Donc, il y avait un double son. Merci. Je vais passer la parole à la représentante de la République du Cameroun. Non, utilisez le micro parce que vous prenez la parole.
La délégation camerounaise voudrait remercier l'honorable commissaire pour la qualité de son rapport et son contenu. Le Cameroun se réjouit des efforts considérables fournis par la Commission pour l'examen et la finalisation des communications, ceci en dépit des nombreux défis relevés, tels que les contraintes financières et le déficit de personnel. La délégation camerounaise voudrait partager avec la Commission certaines difficultés rencontrées pour le suivi des communications. Ces difficultés sont relatives à la réception des communications et à leur réception dans les délais. Elles sont également relatives à la communication des pièces jointes. Vous conviendrez avec nous que de telles difficultés impactent fortement l'élaboration et la transmission des réponses de l'État et conduisent à des décisions par défaut dont vous avez fait mention dans votre présentation. Aussi, c'est l'occasion pour la délégation camerounaise de remettre à la Commission la liste de ces points focaux à travers lesquels la transmission des communications pourra s'effectuer et ainsi la fluidification de la communication entre la Commission et le gouvernement camerounais. Pour terminer, la délégation voudrait se réjouir de l'opportunité d'échange qui lui a été offerte lors de la 73e session ici à Banjul, au cours de laquelle la délégation a pu échanger avec la communication sur l'état, la Commission sur l'état de communication intéressant le gouvernement camerounais. Cela a permis de mettre à jour les différentes informations entre les deux parties. Nous voulons fortement plaider pour que de telles pratiques se poursuivent et soient encouragées par la communication. Cela permettra de résoudre par moment le problème de suivi de communication dont vous parlez. Et enfin, la délégation camerounaise voudrait plaider pour la transmission des décisions, y compris des décisions sur l'irrecevabilité de communication. Parce qu'à certains moments, celles-ci ne parviennent pas aux États. Je vous remercie pour votre attention. Merci beaucoup, Excellence, pour votre intervention. Vous allez avoir par la suite les réponses de la commissaire Abomo. Alors, je vais suivre ici en ce qui concerne les prises de parole. Est-ce qu'il y aurait des institutions nationales des droits de l'homme qui voudraient intervenir suite à la présentation du rapport de la commissaire Abomo? Est-ce que des organisations non gouvernementales ou des associations voudraient également prendre la parole en ce qui concerne des informations supplémentaires suite à la présentation du rapport de Madame la commissaire Abomo? Je n'en vois pas également. Non. Étoile virtuellement. Est-ce qu'il y a des prises de parole? Non. D'accord. Donc, sans plus tarder, je vais demander à la commissaire Abomo d'apporter les réponses les différentes interventions des deux États, à savoir l'Algérie et le Cameroun. Merci. Merci de me passer la parole à nouveau, Madame le Président. Je remercie d'abord les États d'avoir pris la parole pour réagir à l'issue de la présentation de ce rapport. Et s'agissant de la question posée par la République d'Algérie, les rapports sont effectivement disponibles avant la session. Donc là, il s'agit d'un problème technique. Et tout ce que je peux faire, c'est vous présenter les petites plaques d'excuses du groupe de travail. Je n'ai rien à dire. Mon père m'a appris que lorsque vous avez tort, vous demandez pardon et que ça s'arrête. Vraiment toutes mes excuses. S'agissant de la République du Cameroun, Madame le Président, vous comprendrez que je sois un peu mal à l'aise pour en parler parce que je suis camerounaise. Donc, tout ce que je peux dire, c'est que j'ai pris note des difficultés qui sont les vôtres. Je ne peux rien vous dire par rapport aux échanges que vous avez eus avec l'unité parce que je ne participe pas à cela. Mais je crois que les personnes concernées, celles qui sont impliquées et qui ont qualité pour répondre, ont pris note de toutes vos préoccupations. Je voudrais également, au nom du groupe de travail de la Commission, vous présenter des excuses pour les difficultés auxquelles vous avez eu à faire face compte tenu des dysfonctionnements du travail. C'est tout ce que je peux dire. Merci beaucoup. Merci, Madame Abonnet. Merci encore d'avoir marqué cette indépendance par rapport à votre pays d'origine. Alors, je voulais juste également peut-être accompagner les réponses de Madame la commissaire Abonnet en ce qui concerne la confidentialité. Il n'y a pas de confidentialité en ce qui concerne le rapport des commissaires. Comme cela vient d'être indiqué, c'est peut-être un petit aléa technique qui a fait que ce rapport n'a pas été mis sur le site à temps, justement sur le site de la Commission. Mais sinon, toutes les informations sont disponibles et nous concevons très bien que les pays puissent se poser des questions lorsqu'ils ne trouvent pas justement d'accès aux différents rapports. Alors, pour ce qui est... moi, je ne peux pas répondre. Madame le commissaire Maria-Thérèse, le vice-président du groupe de travail peut répondre. Maria-Thérèse, vous avez la parole. Continuez.
Obrigada, senhora presidente. Tomamos boa nota das questões, deixa ainda colocarem no português. Sim. Tomamos boa nota das questões colocadas pela delegação dos Camarões. O que podemos dizer neste momento é pedir ao Sr. Pedro, que coordena esta atividade no grupo das comunicações, para termos um pequeno encontro com a delegação dos Camarões e podermos tirar todas as dúvidas que existirem e também conhecermos quem são os pontos focais que eles sugerem para podermos ter uma interação no sentido de haver melhor comunicação entre Camarões e a Comissão Africana, principalmente no que às comunicações de respeito. Obrigado.
Merci beaucoup, Madame la commissaire Manuela, pour les précisions apportées en tant que vice-présidente de ce groupe de travail. Alors, je vois que la délégation de l'Algérie voudrait, je crois, reprendre la parole. Allez-y, vous avez la parole.
Merci, Madame la Présidente. Alors, très brièvement, d'abord, pour remercier la commissaire Abomo pour la réponse apportée. On prend note. Si c'est possible, de moins de publier le rapport dès que possible ou la déclaration qu'elle a prononcée, cela nous aiderait beaucoup dans les jours qui viennent. Et puis, par ailleurs, j'aimerais faire écho à la déclaration de la délégation camerounaise et notamment par rapport à tous les moyens possibles pour améliorer le travail de la Commission en matière de transmission des communications, que ce soit par un système de point focal ou un système le compte d'utilisateur et de mot de passe sur le site web de la commission afin qu'on puisse avoir accès aux communications transmises, car il est vrai que parfois les États ne reçoivent pas des communications. Donc, je ne sais pas si la commission utilise, par exemple, demande aux ambassades d'Addis Abeba d'accuser réception ou non, mais on encourage la commission et le secrétariat à améliorer ces moyens de transmission des communications, y compris explorer la possibilité de mettre en place un système de point vocal, comme cela existe dans d'autres organisations, et cela en parallèle, bien entendu, à la transmission par le canal diplomatique. Merci.
Merci. Je ne sais pas si Madame Abiola, qui est présente, voudrait apporter quelques explications. Vous représentez le secrétariat concernant la transmission de communications et d'échanges de documents entre la Commission et les États. Madame Abiola.
Thank you very much, Honorable Vice Chairperson. I would like to indicate that our primary line of correspondence with states are the embassies accredited to the AU and to the Federal Democratic Republic of Ethiopia. But when we deal with communications, we have to copy the ministries of justice because these are the line ministries that engage with the Commission when it comes to communications. So this is primarily how we correspond. We write to the embassies in Addis Ababa. We copy the ministries of justice, and we also copy the ministries of foreign affairs. But in some cases, we have had some countries that have indicated their preferred lines of correspondence. We've had some countries that have indicated, for instance, that they prefer for us to correspond with the embassies in Dakar because they are the ones closest to Banjul. So we also take note of this, but we always do go through Addis Ababa. Thank you very much.
Merci beaucoup pour ces précisions. Voilà, donc je pense que ça répond peut-être à la préoccupation de la délégation. Sauf si Madame Abomo voudrait ajouter. Je voudrais rassurer la délégation algérienne que le rapport sera publié incessamment. Vous pouvez être tranquille. Nous avons dit que c'était un quoi, ça va plus se répéter. Donc, aucune crainte à avoir là-dessus. Merci. Merci beaucoup, Madame Abomo, pour ces paroles apaisantes. Alors, est-ce qu'il y a d'autres prises de parole à l'endroit du rapport qui vient d'être présenté par la commissaire Marie-Louise Abomo concernant les activités du groupe de travail sur les communications? Je n'en vois pas. Donc, il n'y a pas de prise de parole, ni des INDH, ni des États, ni des organisations non gouvernementales. Nous en avons donc terminé avec ce point 5 sur la présentation du rapport d'activité des membres de la commission. Ce reste que pour aujourd'hui. Il y aura encore demain d'autres rapports qui sont en instance et qui seront présentés. Nous n'avons pas également d'autres points sur la situation des droits de l'homme. Donc, je pense que nous allons clôturer cette première session de la matinée. Et sans plus tarder, je vais passer la parole au secrétariat pour nous donner la suite des activités pour l'après-midi. Merci.
Thank you, Chair. Following the lunch break, the next item on the agenda is item 6. There's going to be a panel on increasing awareness of the guidelines on freedom of association and assembly in Africa for effective implementation. We'll also have a continuation of item 3, the human rights situation in Africa, to the end of the day. Thank you.
Merci beaucoup. On ne peut que vous proposer effectivement d'aller vers le lunch, même si c'est un peu tôt. Nous nous retrouverons à partir de 14h30 pour la suite de l'agenda. Merci beaucoup.
Oui, d'accord. Si. Bon après-midi, chers participants. Donc, nous allons poursuivre les activités pour le second segment de cette journée. Et nous avons aujourd'hui le plaisir d'accueillir le premier panel organisé pour cette 75e session ordinaire de la Commission africaine des droits de l'homme et des peuples. Il s'agit d'un panel sur la sensibilisation à la mise en œuvre effective des lignes directrices sur la liberté d'association et de réunion en Afrique. Ce panel est organisé par le rapporteur spécial sur les défenseurs des droits de l'homme et point focal sur les représailles en Afrique, accompagné par le groupe d'appui pour la promotion et le suivi de la mise en œuvre effective des lignes directrices sur la liberté d'association et de réunion en Afrique. Comme je l'ai rappelé ce matin, le président commissaire Rémy, qui est donc le rapporteur spécial, est absent. Je vais donc demander au commissaire Derceau de prendre en charge la présidence et la modération de ce panel. Commissaire Derceau, vous avez la parole.
A very good afternoon to you, Madam Vice Chairperson, colleagues, members of the Commission, staff of the Secretariat, distinguished delegates of state parties, international organizations, and civil society organizations, as well as our interpreters. Welcome to this first panel discussion of this organization of the Commission. This is the session as the Vice Chair introduced on the effective implementation of the guidelines on freedom of association and assembly in Africa. As you are aware, one of the mandates of the African Commission on Human and People's Rights is to elaborate guidelines, principles that provide answers to legal questions on various fields of the social and public life of our societies. And the African Commission on Human and People's Rights some years back developed these guidelines on freedom of association and assembly. And the effective implementation of these guidelines requires this kind of engagement between the Commission and the wider constituency of the African Commission on Human and People's Rights, including most notably states parties who have the primary responsibility for the implementation of the rights enshrined in the African Charter, national human rights institutions, and civil society organizations. It is a pleasure for me to moderate this panel in the place of the chair of the Commission, who is responsible for organizing this panel. We have the members of the panel with us here. We will start with Ms. Irene Petras, Senior Legal Advisor, Africa, the International Center for Not-for-Profit Law, ICNL, who would be discussing about the guideline on freedom of association and assembly, with a focus on highlighting key themes or salient issues from the guidelines. That would be followed by Councillor Lepeli Moketsi, Program Officer, Senior Legal Center, who would be addressing us on the role of civil society organizations in the promotion of the guidelines. That would be followed by Ms. Colette Letlojane, Executive Director, Human Rights Institute of South Africa. She would be providing us insights on the standardized monitoring framework and country experiences resulting from using the tool in the SADC, the Southern Africa Development Community region. Then we have Mr. Dine Hassan, Secretary General, National Human Rights Council of Côte d'Ivoire, on the role of national human rights institutions in promoting the guidelines for their effective implementation. Representing State Party, Mr. Mike Chinoko, Director, Malawi Law Commission, would provide us insights on State Party's perspectives. And then we would have interaction session thereafter. Now, I would like to give the floor to Ms. Irene Petras. You have, as I understand, 10 minutes, please. Thank you.
Thank you, Commissioner, and good afternoon, everybody, Madam Chair and Commissioners. The guidelines on freedom of association and assembly were adopted 6 years ago at the 60th ordinary session in Niamey, Niger. And previously, a study group had been mandated by Resolution 319 of 2015 to develop these guidelines under the supervision of the Special Rapporteur on Human Rights Defenders. The guidelines have got two major objectives. The first is to clarify freedom of association under Article 10 and freedom of assembly under Article 11. The second main objective is to strengthen the obligations which are set forth in these articles. This has really been pioneering guidance by the African Commission. They have produced these guidelines along with many other guidance on other subjects here, way ahead of mechanisms in other regions and other multilateral institutions. Globally, General Comment 37 of the United Nations, which deals with freedom of peaceful assembly, was only adopted in July 2020. And only very recently in 2023, were Inter-American Principles on Civil Society Organization Laws adopted. And they drew very heavily from the process of the African Commission's development of these guidelines. So we can really say that the Commission has been one of the pioneers of producing this guidance. But whether or not we are taking advantage of that and really using this guidance is the big question that perhaps we'll address today. The guidelines themselves set out fundamental principles, 10 fundamental principles for how to view freedom of association and assembly in Africa. And then there are two parts to the guideline. The first deals with freedom of association, and it lays out very clearly guidance around the legal framework, legal personality, the purposes and activities of non-governmental organizations and other associations, oversight and internal governance structures, financing, reporting, and then sanctions and remedies. The second part of the guidelines deals with freedom of assembly. And again, these guidelines set out guidance on the legal framework. It looks at the notification regime for associations and gatherings. It looks at the scope of limitations and then protections and sanctions and remedies. So these are the guidelines in a nutshell. And my task is really just to talk a little bit about the importance of the guidelines. And I believe that there's about three main areas. The first is the guidelines are important for producing laws, policies, which comply with the African Charter and with state parties' obligations to respect and promote freedom of association and assembly. When we look at how legislation has developed, my organization, ICNL, tracks legislative developments and the impact on freedom of association and assembly. And over the past 5 years in Africa, about 91% of legislation which has impacted on freedom of association and assembly has been restrictive. So it doesn't comply with the guidelines. The laws which make up that 91% are things like NGO laws, which we call life cycle laws, laws that deal with freedom of expression, laws which deal with surveillance and the right to privacy, cybercrime laws, counterterrorism and anti-money laundering laws, and funding laws. So those make up most of the restrictive legislation. And one of the important things about the guidelines is that we have produced as the support group these checklists that legal drafters can use, either when they're drafting legislation, when they are looking to assess the compliance of this legislation with the African Charter. And I believe that if we do use this checklist and the guidelines, we'll be able to improve a lot on these legal frameworks that are affecting the ability of civil society to operate on the continent. And again, these checklists and that are useful tools for civil society to be able to play an oversight role, and also for national human rights institutions to be able to properly advise on legislation that is being proposed. The second is that the guidelines are also, they provide guidance for state implementation, protection, promotion, freedom of association and assembly. While we've seen that there's been a lot of activities that involve civil society and using these guidelines, and we'll hear some of that today, states have not been very proactive in taking up these guidelines. It could be that there is not a lot of awareness of the existence of the guidelines or how to use them. But one of the aims of the support group is to provide training, capacity building, and information dissemination for states to be able to know more about the guidelines and how to use them. One of the other things which the support group is working on is developing a guide to include reporting on the guidelines within state party reports and shadow reporting. And we hope that by the next session, we would have for preliminary consideration a draft of those guidelines. The final point, I think the importance of the guidelines is around helping us to strengthen and make more effective our monitoring of freedom of association and assembly. We would be able to then use both the Commission, state parties, CSOs, national human rights institutions, early warnings which come with monitoring. We could assess the trends that are happening on the continent or in particular regions, and then be able to make interventions, whether it's where we see an opportunity for improvement and reform, or where there is need for protective mechanisms to come in. And in this regard, the support group is looking at starting to develop a tracker where we could collect laws, policies, practices that either strengthen or violate the guidelines, verifiable evidence, but that then can be used to take action on the part of the Commission itself. I'd like to end just by flagging that when the guidelines were developed, there was an understanding, obviously, that we are constantly in a state of flux, in a state of development, and there's always new and emerging trends that continue to impact on freedom of association and assembly. We've seen this with COVID-19, where there were introductions of emergency measures that had an adverse impact on these rights. We see the impact of climate change, for example, climate refugees and IDPs. What is this climate change and climate emergency going to mean for rights to freedom of association and assembly? And then digital developments. The general comment, which I mentioned previously, deals with digital rights and technology and its impact on freedom of peaceful assembly. And so these are some of the issues that we need to constantly document and look at case studies. And perhaps with an update of case studies, we would be able to look at the guidelines and see whether there's a need to update those themselves or whether we can still use them for those emerging trends. So thank you, Chair. I'll end there. Thank you.
Thank you very much, Irene, for outlining for us the content of the guidelines and the salient issues arising from the guidelines, including the last aspect of your intervention about the application of the guidelines in respect of emerging developments, let's put it that way. Whether or not that would require an updating or review of the guidelines, I wonder if that is too soon to say. I'm sure the nature of the framing of the guidelines is such that it would allow them to be applied to these conditions as well. But I think it's a very important point to reflect on. Next would be Councillor Lepeli Moketsi. You have 7 minutes, please.
Thank you very much, Honorable Commissioner. Madam Chair, Honorable Commissioners, State Delegates, representatives of national human rights institutions, colleagues, ladies and gentlemen, constitutional provisions and legislations are but a first step towards the realization of the rights to free assembly and association. Hence, this study, which we are discussing today, the 4 selected Southern African countries, namely Malawi, Lesotho, South Africa, and Democratic Republic of Congo, have such constitutions and legislations guaranteeing the enjoyment of right to freedom of association and assembly. Challenges emanating from the legislations and state practice on the right to freedom of assembly and association in Africa are almost identical. For purposes of this panel, Madam Chair, reference will be made to Lesotho as we have been promoting the guidelines and monitoring their implementation in the said state. Assemblies and demonstrations in the country are governed by Public Meetings and Processions Act of 2010. The Act makes it mandatory for everyone intending to hold a public meeting or procession to first seek and obtain permission from either the police or headman of the area where such a meeting or procession is to be held. The Act therefore gives the police and headmen discretion to allow or prohibit the holding of a gathering. This Meeting Act I'm referring to has faced controversy as it is regarded as limiting rather than advancing the right to freedom of association and assembly. On the other hand, there are those who view the Act as a necessity because it has introduced limitations on political interference with those rights. The Penal Code of Lesotho allows the use of force to effect arrest or prevent crime. Police routinely use this code to stop assemblies and demonstrations, even where such are peaceful. For instance, in 2014, police were reported to have used live ammunition to disperse a protest by nurses in Lesotho. The strike was largely peaceful. In 2018, police fired rubber bullets and water cannons on demonstrators who had gathered peacefully in industrial area outside the capital of Maseru. And in June last year, police fatally shot and killed one Kopano Makutwani during protest by the National University of Lesotho students over their allowances or stipends. On its face, Madam Chair, it appears that this legal frame is in line with international standards and guidelines. However, the practical implementation of this framework is seriously compromised. It is evident that the power to grant or withhold a permit is exercised in a manner that does not give effect to the right to assembly and association. The application process itself is far from transparent. and power remains overwhelmingly in the hands of the authorities to determine whether to grant permission. Granting of permission to assemble and demonstrate is often based on political considerations. In many cases, there seems to be no rational or reasonable basis to deny permits. Police routinely deny permissions for meetings and processions, especially to those deemed to be against government. It often takes court interventions to have such gathering or demonstration takes place. A trend in the Southern region is that states have what appears to be a comprehensive regulatory framework of the regulation of right to peaceful association and assembly. However, a deeper examination of their frameworks demonstrate that they have been used to limit rather than facilitate the ability of citizens to exercise their right to peaceful assembly and association. It is imperative for states like Lesotho to create an enabling environment for the exercise of rights to peaceful assembly and association. And they can do this by capacitating their institutions to properly implement the provisions of their enabling legal instruments in line with the African Commission's guidelines on the freedom of association and assembly in Africa. The 4 Southern African countries mentioned, which are featured in this study, are no exception to the general approach by states of seeking to limit what is otherwise guaranteed under international law. Civil society and human rights defenders face danger in antagonized environments characterized by restrictive legislations, reprisals, intimidations, life threats, extrajudicial killings, and abductions. Therefore, CSOs and human rights defenders have a critical role to play in ensuring that states are held to account and that the democratic and civic space is continuously expanded by ensuring full implementation of the guidelines on the freedom of association and in Africa. I thank you, Honorable Commissioner.
Thank you very much for also saving us 1 minute from the time, which clearly communicates the gap between what is said in the guidelines and the practice of states. The practice, both as it relates to the applicable law, as cited in the case of Lesotho, but also the kind of actions that states engage in terms of freedom of assembly and association as it relates to peaceful protest, which is an aspect of the right to freedom of assembly that is protected under the African Charter on Human and People's Rights. And this example clearly illustrates the significance of these guidelines in order to make sure that both the laws and practice of states is aligned with the African Charter on Human and People's Rights. Thank you very much for that. I now pass the floor to Madam Colette. You have 10 minutes, please.
Thank you very much, Commissioner Ederson, the moderator of this panel. I also want to take the opportunity to recognize the Deputy Chairperson of the African Commission, members of the African Commission, and state parties, national human rights institutions, civil society, colleagues, ladies and gentlemen. I would like to take this opportunity to congratulate the African Commission for developing this concept on freedom of association and assembly guideline sensitization panel that increases awareness for effectiveness of implementation of the guideline. And I also wish to thank and commend the state parties that supported the civil society study group and members of the support group in Benin, Togo, Ghana, Niger, during the development of the guidelines
that brought to their adoption in 2017. As Irene has elaborated, the guidelines are founded on core human rights values from the African Charter on Human and People's Rights, the Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, and other instruments like the Protocol on the Rights of Women, Children's Rights, and many others that we have. They were specifically designed to assist member states have better understanding of enacting laws that are going to give effect to the guaranteed right as stipulated in Article 1 of the African Charter. Article 10 and 11, they guarantee freedom of association and assembly. These rights are the cornerstone of democracy, justice, morals, peace, and democracy. They are the hallmark of civil and political rights, and they are the rights that facilitate others, like your economic, social, and cultural rights, and as guaranteed in our constitution and regional and international human rights instruments. For us, as a SADC region, as civil society, we were very humbled by the process that unfolded that ended up with the adoption of the guidelines. We realized that member states were not familiar with this document, and we decided after capacity building and engagement in our countries to develop what we call the standardized monitoring framework. The standardized monitoring framework, was another process that was making it very easy for human rights defenders, civil society to use in the country to collect data so that we have accurate information. We are able to engage the African Commission on Human and People's Rights with accurate information. This was used as a pilot. We conducted a pilot project in 4 countries, DRC, Malawi, Lesotho, and South Africa. And in terms of this, Irene has mentioned the 10 principles that are highlighted in the guidelines. We use the very same 10 principles in assessing the impact of implementation of freedom of association and assembly. The laws, as far as the guidelines is concerned, they must have human rights. They need to follow human rights approaches. The laws are not supposed to be arbitrarily developed without considering the principles that are enshrined in the African Charter and also as codified in the guidelines. And it also, in terms of the personality formation of domestic association, the number of persons that are required to form an association, the guidelines are very specific of that number. 2 people can form, and everyone is entitled to form an association. We have countries like in South Africa, the NPO Act, it recognizes that everyone is entitled to operate or to form an association, and it does not discriminate upon anyone based on their sex, religion, or political affiliation. However, in other countries like in Malawi, we realize that sexual orientation and gender identity organizations are not allowed to register. And if those organizations are not able to register, their right to fulfill all guaranteed rights in the African Charter and other instruments are limited. And we also learn from other countries that actually compulsory mandatory registration is to the detriment of civil society, such as those that are fulfilling activities that are unpopular as far as the government is concerned. And they miss understanding that registration should encourage, should give opportunity to civil society to thrive, because the civil society is contributing towards economic development of the country. And the association as well, they are required to have their own governance structures as far as the guideline is concerned, must be independent from government because they will be fulfilling their own objectives, including doing their own fundraising without any interference from the state. They are governed by laws, and where they cannot, they can be held accountable for violating the laws of the country, which are very specific. For example, those laws, if they are limiting, they must be justified. It must be legally necessary for the government to come up with those registration and notification. In other countries, we realize that where they have the statutes, they have the constitution, they have the names of the governance, they have the objectives, they've got even plans of the organization. That notification in itself qualifies as a way of, it gives them the opportunity to be recognized as registered. In other countries, registration, it takes many months whilst association are awaiting registration and for them to enable them to receive the funding. And then also in terms of the activities of associations, the associations that work on governance issues, that are monitoring corruption, that are monitoring that exercise freedom of expression. For example, we found that those associations, they are always attacked. They suffer from surveillance, and they are also experiencing challenges on the ground of their facilities being burgled, being targeted, even their homes, and also extrajudicial killings, arrests, arbitrary arrest, and malicious prosecutions that's happened to those organizations. These organizations, they are promoting the constitution, they are promoting the rights that are enshrined in the African Charter, for example, and treaties that the countries have ratified. We have also realized that when it comes to freedom of assembly, the laws as well are very restrictive in terms of notification. Notification is always confused with authorizations. Members of law enforcement, they use that notification as authorization because there's banning of protests, there's banning of gatherings because authorization has not been provided. The guidelines is very explicit about constitutional rights and the rights that are in the African Charter, that members of law enforcement should facilitate assemblies and gatherings. We have countries, for example, in South Africa, gatherings were forbidden for many years. Now these rights are enjoyed in the constitution, and the citizens, as long as they are less than 15, they are regarded as legal if they conduct such a gathering. However, the Constitution of South Africa has passed a judgment that even strengthen the rights of the citizens, that you can demonstrate without being authorized, without receiving that procedural aspect. Now, this issue of notification, we've seen the selective of permission of protest. There are high-profile protests that can be allowed to take place because maybe some of the protesters or the managers or the conveners, they are targeting or they are attacking the judiciary, and the judiciary maybe has passed some judgment that are not, that don't border well with some of the people that are advocating for that. And we've seen that. such a selective way of applying as associations or assembly is to the detriment of the guidelines. I thank you very much.
Thank you, Colette. The experiences of countries with respect to, I think, the guidelines, again, I think building on what has been shared, reinforces that perhaps the narrowing civic space that in the course of this session and previously various members of this house have raised are being reflected here. I think these provide useful food for thought as we reflect on how to improve the state of the civic space to ensure that it is in accord with the standards of the African Charter and therefore reflects the vision that is encapsulated in the guidelines. The next speaker is Mr. Dain Hassan, who would be joining us virtually. And this is from the National Human Rights Council of Cote d'Ivoire, providing us a perspective from the National Human Rights Institute's perspective, since the implementation of these guidelines also depends on the role that national human rights institutions play. Etwell, do we have the participant, the member of the panel? Good. You have the floor, please, for 7 minutes.
Merci beaucoup, Monsieur le Président. On m'entend?
Yes, we can hear you.
Est-ce que je suis entendu?
We can hear you. Please proceed.
Merci, Monsieur le Président. Merci à Madame la Présidente de la séance, aux honorables commissaires de la Commission africaine des droits de l'homme, à l'ensemble des panélistes. Merci, chers distingués participants.
Looks like that the interpreters are not getting your voice. I don't know where the disconnect is. Let's try again, please. You can go ahead, please.
Vous voudrez
Go ahead.
Alors, merci beaucoup, Monsieur le Président. Merci de l'invitation de notre Institution nationale des droits de l'homme à prendre part à ce panel sur le rôle des institutions nationales des droits de l'homme dans la promotion des lignes directrices de la Commission africaine des droits de l'homme et des peuples sur la liberté d'association et de réunion en Afrique pour une mise en œuvre efficace en Afrique de ces lignes directrices. Je voudrais vous partager, en tout cas, faire un focus sur l'expérience de notre Institution nationale des droits de l'homme sur la mise en œuvre de ces lignes directrices à travers mon intervention pour comprendre le rôle que devraient jouer et que doivent jouer les institutions nationales des droits de l'homme dans la promotion de ces lignes directrices. Alors, permettez-moi de rappeler que notre institution, au travers de sa loi habilitante, exerce des fonctions de concertation, de consultation, d'évaluation et de proposition en matière de promotion.
With the sound.
On ne m'entend pas.
Interpreters are not able to get the sound from where they are.
The sound? Hello?
Can you speak a bit closer to the mic?
Mr. President, vous m'entendez? Vous m'entendez?
Me, I can hear you, but interpreters are not able to hear you. That's the problem. So your presentation is not being translated.
Ah, OK. On peut continuer?
Let's try, please. Yes, please continue.
OK, thank you. Alors, je disais que notre institution exerce des fonctions de concertation, de consultation et de proposition en matière de promotion, de protection et de défense des droits de l'homme. Conformément à sa loi habilitante, l'institution contribue à l'élaboration des rapports prescrits par les instruments juridiques internationaux auxquels la Côte d'Ivoire est partie. Membre de plusieurs réseaux d'institutions nationales des droits de l'homme, le Conseil national des droits de l'homme est affilié auprès de la Commission africaine des droits de l'homme et des peuples depuis la 56e session du 21 avril au 7 mai 2015. À ce titre, et tel qu'il résulte des dispositions des articles 26 et 45 de la Charte africaine des droits de l'homme et des peuples, le Conseil interagit avec la Commission africaine des droits de l'homme, ce qui établit un cadre de collaboration entre toutes les institutions nationales des droits de l'homme et la Commission. Alors, à ce titre, les institutions affiliées à la Commission ont entre autres obligations d'assister et de participer à des séances publiques, des sessions de la Commission et de ses organes subsidiaires suite à une invitation permanente à la session de la Commission, de promouvoir la Charte africaine des droits de l'homme et des peuples, s'acquitter à cet effet des obligations suivantes, de faire une déclaration en 5 minutes sur la situation des droits de l'homme et les activités réalisées dans le cadre de leur mandat. Alors, la bonne interaction des institutions nationales des droits de l'homme avec la Commission permet non seulement d'être au fait de l'évolution de la situation générale des droits de l'homme sur le continent, mais de participer à la recherche de solutions pour faire face aux défis, notamment par un soutien à l'élaboration des lignes directrices, telles que les lignes directrices de la Commission sur la liberté d'association et de réunion en Afrique, et mieux à veiller à leur bonne application au sein des États. La bonne application impliquant l'appropriation du contenu des lignes directrices, la promotion de celles-ci par la vulgarisation au sein des différentes strates de la société. Alors, pour ce faire, au sein du Conseil national des droits de l'homme, il existe un département chargé des droits civils et politiques qui travaille sur la promotion de tous ces droits et libertés publiques au regard de la Constitution ivoirienne du 8 novembre 2016 et des ratifications, notamment le Pacte international relatif aux droits civils et politiques, la Charte africaine des droits de l'homme et des peuples. La Constitution ivoirienne reconnaît et protège explicitement le droit à la liberté d'association et de réunion en son article 20 qui stipule que les libertés d'association, de réunion et de manifestation pacifiques sont garanties par la loi. Au travers donc de ces 31 commissions régionales reparties sur l'ensemble du territoire national, le Conseil national des droits de l'homme veille à la mise en œuvre de cette disposition constitutionnelle et documente systématiquement tout obstacle ou volonté de ne pas permettre la réalisation de ce droit à la lumière des lignes directrices. Par ailleurs, le Conseil national des droits de l'homme plaide depuis 2015 pour la prise d'une loi spécifique devant régir les organisations de la société civile, car la loi actuellement en vigueur, notamment la loi de 1960 relative aux associations, prescrit à la réalité un régime de confusion puisqu'elle prend en compte toutes les associations non lucratives. Le Conseil également interagit avec les mécanismes internationaux, par exemple en plaidant pour la bonne interaction de la Côte d'Ivoire avec les mécanismes dédiés à la protection des droits par la solution de la et la mise en œuvre des observations conclusives et recommandations, notamment le Comité des droits de l'homme, la Commission africaine des droits de l'homme et des peuples, l'examen périodique universel, les procédures spéciales de l'honorable Rémi Ngoï-Lumbu sur les défenseurs des droits de l'homme et point focal sur les représailles en Afrique. Par exemple, l'évaluation des rapports étatiques permet, au cours du dialogue interactif, d'approfondir la compréhension de sur les implications du droit à la liberté d'association et de réunion garantie par les articles 10 et 11 de la Charte africaine. En outre, En collaboration avec le Service international des droits de l'homme et la Coalition ivoirienne des défenseurs des droits de l'homme, l'honorable Rémi Ngoï Dombo a effectué plusieurs missions en Côte d'Ivoire pour booster le plaidoyer de mise en place du mécanisme de protection des défenseurs des droits humains prévu par la loi et le décret sur la promotion et la protection des défenseurs. La bonne pratique que le Conseil voudrait partager est d'amener les INDH à contourner la difficulté de l'autorisation officielle d'une mission des titulaires du mandat par une invitation de l'INDH et même avec l'appui des acteurs de la société civile. Au final, les résultats sont identiques car une fois le titulaire du mandat dans un pays, celui-ci a la même possibilité comme une mission officielle de rencontrer les autorités et donc de dresser un communiqué final et un rapport de mission. Cela permet de veiller à ce que l'espace civique ne soit pas restreint et de permettre une pleine réalisation des activités liées avec les lignes directrices de la liberté d'association, de réunion et de manifestation pacifique. Pour ne pas pas de liste, chers participants, Monsieur le Président, telle est l'économie de la contribution du Conseil national des droits de l'homme et de son rôle dans la promotion des lignes directrices de la Commission africaine des droits de l'homme et des peuples sur la liberté d'association et de réunion en Afrique pour une mise en œuvre efficace en Afrique à l'image d'autres INDH. Je vous remercie.
Thank you very much, Mr. Hassan, for sharing with us the experience of the National Human Rights Council of Cote d'Ivoire with respect to the promotion of the guidelines on freedom of assembly and association, including through advocacy for the adoption of relevant legislation in that respect. We now move on to our last speaker, Mr. Mike Chinoko. You have the floor for 7 minutes, please.
Thank you, Commissioner Dixon, moderator of this session, Deputy Chairperson and other commissioners, fellow panelists, distinguished delegates. I'm here to provide insights on from the state's perspective on the issue of guidelines on freedom of association and assembly. Particularly being from Malawi, I'll focus on Malawi. In terms of Malawi, I think the starting point is our constitution, which guarantees the right to freedom of association in section 32. And also in another section, it guarantees the right to assembly and the right to demonstrate with others peacefully and unharmed. From there, of course, there is now local legislation, which is kindly providing more details with regard to these rights, operationalizing them. But of course, they are borrowing a leaf from applicable international law. And in this respect, I think more in point is International Covenant on Civil Political Rights, specifically Article 22, which guarantees this right to freedom of association, but at the same time also allows state parties maybe to place restrictions to this right, but only those restrictions which are prescribed by law and which are necessary in a democratic society, and those which would be in the interests of national security, public safety, public order, protection of public health, morals, or the protection of the rights and freedoms of others. So in that regard, enabling legislation in this area, I think was enacted in this respect. I should mention that up to around 2010, Malawi was using a very old police act enacted as early as 1946. But there was a comprehensive law reform process that the country undertook, which led to the promulgation of a new police act, which came into force around 2010, and which has a comprehensive part dealing with regulation of assemblies and the demonstrations in light of what the Constitution prescribes and in light of applicable international law as stated. So I think primarily the right to freedom of assembly and the right to association are being domesticated and are being respected in that law. Only that would say that the restrictions that are there are only those that are being perceived as necessary and also proportionate. For example, the law in Malawi is that the scheme under the that is applicable in the police code is that of notification rather than authorization, as our colleagues have stated. But of course, there have been isolated incidences where law enforcement officers have kind of refused permission for some officers, for some civil society actors to demonstrate. But fortunately, our courts have been very vigilant in that respect and have at all times and in many occasions upheld the constitutional right to assembly. And in many, I think I can't even remember one where the parties went to court and then they were even refused permission by the courts. The courts in Malawi have always respected these constitutional rights as appearing in the constitution and as well as applicable international law, and allowed peaceful demonstrations to continue. Even from the state's perspective, because in some cases, it was actually the police itself that would refuse permission for people to demonstrate. When the court has, in the cases where the court has given a go-ahead for the demonstrations to proceed, then we have seen that the military have come in to protect the demonstrators in order to avoid the perception of the bias that like it's the police were refusing, how can they provide adequate security? So the military would come in that respect to make sure there's orderly, orderly procession of the demonstrators and that the rights of others in terms of the are not affected, like where damage will be caused to other people's property, or people are still, able to move freely, traffic is able to flow freely within the spheres of the public, and that demonstrations are conducted in an orderly manner. So I would say that in a way, the legislation is more into giving effect to the provision on freedom of assembly and the right to join as an association, of course, with some restrictions that are addressing national security issues or sometimes public safety and public order, and also protection of morals. So I note that the report that my colleagues have ably presented here, very correct in many respects, and I think it has made recommendations for Malawi, some of which are that it wants to remove the requirement for compulsory registration of civil society organizations. Of course, I think Malawi has moved on from that. Indeed, it has enacted an amended NGO bill. I think it was passed as early as recent as February this year, which is making it mandatory that all CSOs must be registered to operate in Malawi. But that in itself, in my view, does not preclude any civil society organization which is not registered or which is not so properly organized to exercise the right to assembly or indeed to join, because the Police Act which I mentioned is using the word convener. And convener in that respect is both a natural person and a legal person. So anyone has the right to initiate that, to exercise those rights, to demonstrate. It could be a person mobilizing a group of people. They have the right to do so under the Constitution and as well as under the applicable law on Police Act, because they're coming in as an individual. But if they do come in as an organization, all what the law requires is for them to identify a convener for that purpose. They should meet the law enforcement and local government authorities to agree on the time, the place, the route, and things like that, so that things are proceeded in an orderly manner. But it does not really, the law does not really say that if you are not registered, then you cannot exercise these rights. You can exercise these rights in your individual capacity as a convener, assembling a group of people. The other one, I think, was that maybe this proposed NGO amendment bill should not come into force. As I said, maybe that has already been overtaken by events because it's been enacted. And as I said, I repeat that in my view, it does not impede on any of the rights that we're talking about as of now. Be that as it may, I think there's still a window for further incorporation of the guidelines, if indeed some of the things have been left out, because under the same Police Act, I think Section 111 of the Act gives power to the minister to make regulations for the effective carrying out of assemblies and demonstrations under that Act. So that is a window and an opportunity where we can further domesticate the guidelines that have been adopted by the Assembly in 2017, if ever something else is missing. But overall, I guess the enabling environment is permissible and amenable to the exercise of these rights. And it has further been amplified by the pronouncements of the court several times and repeatedly on these matters that you cannot derivate from these rights. I thank you very much, Chair.
Thank you very much for sharing the experience of Malawi. I think this last presentation provides us and then in a very nice way, ties the different presentations together. First, in terms of issues relating to legislation. As you can see from the presentation, the freedom of association and assembly may not be affected by one piece of legislation only, that they would be affected by a wide range of legal acts. Here, reference was made to the Police Act. Later on, the amended NGO law was also highlighted and cited. Obviously, we have to make a distinction between the different laws that apply with respect to freedom of assembly and that which apply to freedom of association. There is a connection between them, but they are not one and the same necessarily. I think that's important. Second, on the question also of litigation, the role of courts, that is also another issue that have been highlighted in the presentation, particularly with respect to the exercise of the authority that is given to police under the Police Act vis-a-vis the convening of protests or assemblies. Examples have been given where the police actually refuse to allow the convening of assemblies, which were then taken to court, and the court upheld the right of those who sought to exercise their freedom of assembly. Questions relating to whether NGOs should be registered or not is one of the issues that have been highlighted from the different presentations based on the guidelines and the implication of that through the example of Malawi, which actually in its amended NGO law requires registration. What does the implication of that? Does that mean those that are not registered become illegal and therefore couldn't be able to function? Is part of the question that arose. It's not clear whether or not the Police Act actually would be the basis for saying that those that aren't registered indeed can operate, because assembly and association are different things. Then there is also the question of notification and authorization, which are also different issues. So I think with those very rich presentations, the floor is now open for interventions from participants. We have registered participants. I will start with the registered participants. First, there is a state party from the Ministry of Justice and Human Rights of Guinea, the Republic of Guinea. I think Lua Fernanda registered to intervene virtually. Looks like that we don't have Lua Fernanda at the moment. So the other one is from NGOs, MAAT for Peace, Development and Human Rights, Basant Essam. This is the NGO with observer status number of 528. Do we have Basant Essam? Okay, you have the floor, please.
Thanks for giving me the word. Thanks. MAAT for Peace, Development and Human Rights expresses its deepest concerns about the conditions of the right of peaceful assembly and association in the African continent, especially in the Horn of Africa, where the authorities in the Horn of Africa have carried out inhumane practices against these demonstrators in Somalia, Djibouti, Ethiopia, Eritrea, and Sudan. For example, in Somaliland, security forces harassed and detained protesters during the 9 June 2020 and 11 August 2020 demonstrations organized by opposition parties, according to Parliamentary Committee report. During the 9 June 2020 protests, Somaliland security forces harassed opposition MPs and their supporters by using live ammunition and tear gas to despair their gathering. Officials of 25 opposition parties were arbitrarily arrested and detained without charges. For 25 days. During the August 11, 2022 protesters, the opposition Wadani party reported that 14 parties officials were arrested and released after a week without charges. In addition, Al-Shabaab party does not allow any gatherings without its prior approval. In Eritrea, proclamation number 145 for 2005 obliges the few organizations present in Eritrea to implement their programs as long as they are in partnership with government entities, further restricting their activities the existence of many non-governmental organizations in a country is a manifestation of the right of its member to freedom of association. And this does not clearly exist in Eritrea. In the same context, MAAT would like to urgently call on African countries to abide by what was stated in the guidelines of the right of freedom of peaceful assembly and association that was adopted in May 2017, and to amend their national legislation in accordance with what was stated in the guidelines. MAAT appeals the government of Eritrea not to view NGOs as a threat or to allow NGO members to exercise their rights of freedom of association. Allowing NGOs to exist freely would bring multifaceted benefits to society and give the government an opportunity to focus its resources on other issues. Thanks.
All right, thank you. I don't know if there is any other request from the House for intervention on the theme of this panel. Okay, I don't see any request from the House. Anyone online? Oh, okay. All right. I didn't see your hand. Please go ahead. If you kindly identify yourself as well.
Thank you very much, Honorable Commissioner, for the floor. I wanted to just make a few comments on the presentations that have been made, especially with the social that's and comply with the guidelines, especially on a number of areas, including legislation. I want to make a clarification on legislation. The new NGO is made it available for NGOs to register. What this means is that an NGO that is not registered cannot operate. Not only can it not operate, but it also needs supply, needs funding instead to registration. So if you're not registered, you cannot get funding. That is not all. It also means that the NGO, the association that is not registered, cannot litigate in court. I feel that because the recognition of so you can see that the requirement of decision is having implications on the exercise of our rights, including the right to seek justice. And not only that, the decision is not to the court for the decision. For organizations to be registered, must be just to give an example, for an organization of our home, especially for administration is which means it's a status, you need to renew registration, and that comes with a cost. And the cost is calculated based on income for the previous year. And you know, when the commissioner, that NGOs are not into business. We depend on funding. The fact that we had funding the previous year was not guaranteed that this year. We had funding last year, and this year it was funding. So the registration fee is based on the previous funding, and this year it was registered. So those are some of the challenges that we organizations in Malawi, are facing. Currently, if you look at the website of the NGO Regulatory Authority, you see what I'm talking about. There are so many NGOs in Malawi, but very few have been able to meet the requirements of registration. Almost over half of NGOs do not meet the requirements. What this means is that all those NGOs that do not meet the requirements do not have currently registration status. These are the challenges that we are facing. And also, to get registered, as I said, all these requirements that you have to meet. The challenge is mostly NGOs that are promoting what are termed as sensitive issues. LGBT organizations in Malawi have been registered. Currently, there's a case in court regarding the Nyasa Rainbow Coalition, which has been denied registration consistently since 2016. There's also the case of the Association of Secular Humanists, who have also struggled to get registration. So this issue of registration has so many implications, and it's important that the Commission should help us in terms of making recommendations to the states to ensure that the registration is not infringing. I wanted to finish with the issue of December. In Malawi, and I believe it's the case in many other African states, the requirement for notification has been grossly misinterpreted. There have been so many cases in Malawi. My colleague from the Ministry, from the government side, said there have been isolated incidents, but there have been so many incidents in which NGOs or associations have been denied the right to assemble just because they did not get permission. And yet the law is not talking about permission. The law is simply talking about notification. That an NGO or an association that wants to demonstrate should simply notify the district commissioner and the police commission. But that has been misinterpreted to mean that the NGO should be organization. So those are some of the things that I wanted to convey. I hope the parents recommendations provide to ensure that this one is
some of the requirements relating to registration. When we talk about registration clearly, the requirements of registration is not just to go and get some kind of preventive, and you get some later, but you are recognized without additional such as to fees. And then the program will be for the owners and compared to the previous legal regime, the current regime seems to be much more restrictive. And it's leading to quite a significant number of NGOs, not being everything, but so there is something that requires us to further reflections and indeed the purpose of the guidelines is exactly to address these kinds of requirements in the face of it that we see restricted, but they have the principles of restricting freedom of association. And I think the second thing relates to that we, like the law says, with respect to assembly, the notification based law, understanding of those implementing it, because we can give them the take it as thank you very much. Vice Chair,
les législations nationales ont une apprendre des lignes directrices sur la liberté d'association et de réunion. Et pour cela, le gouvernement de plus de ces différentes dispositions
certaines restituées beaucoup plus loin, en admettant que la liberté d'association de réunion doit avoir sur le monnaie organique. Parce que ce type de loi existe dans ce pays, donc à peu près, dans le pays, de l'ordinaire. Donc, ce sont toutes ces règles organiques qui sont en considération pour pouvoir vérifier la substance légale politique de la liberté de réunion et d'association. Au-delà discrétionnel dans l'application de la liberté de réunion et de la liberté d'association, il faut également se poser la question de la mise en œuvre, quels sont les activités qui pourraient effectivement entraîner la sensibilisation et la discrimination de plusieurs classes. On a bien vu les institutions nationales de travail, les organisations de la société civile. Moi, j'ajouterais également aussi les universités, les cliniques juridiques, les prix des universités, les je vais donner un exemple important dans la discrimination de ces deux électrices. Donc, régulièrement, il faut poser la question à certains, quelles sont les règles de personnes qui, effectivement, sont capables d'avoir l'exercice de permettre la classe sociale de liberté de réunion. Donc, je pose cette question, parce que quelle est la considère que celles de ces parlements peuvent exercer cette liberté. Donc, je sais très bien que dans cette catégorie, on est citoyen qui peuvent exercer la liberté d'association et la liberté de réunion. Moi-même qui suis en charge de la question des réfugiés, je sais que la Convention de 1951 révèle la liberté d'association et de réunion pour les réfugiés, à condition de la liberté également l'objectif politique. L'objectif politique. Même les réfugiés se doivent réaliser une solution d'association à l'école et à la réunion. Donc, ce sont des questions également qui peuvent être considération. De l'autre côté, ce qui se développe de ce panel, ce que je veux dire, c'est qu'on peut également une chance de bonne pratique. Ce qu'on appelle de bonne pratique, c'est également avec une meilleure pratique. Donc, il y a des structures de bonne pratique et de meilleure pratique. Donc, certains exemples nous ont effectivement éclairé sur ce que j'appellerais les meilleures pratiques et effectivement les écoles, les obstacles auxquels les associations se heurtent. D'abord, pour créer une association, on a vu que le régime soit de la déclaration, également le régime de la déclaration et également de l'autorisation qui peuvent parfois faire défaut. De même, en ce qui concerne la liberté de réunion, la liberté notamment de manifestation, mais aussi il y a des obstacles pour que ces libertés sont parfois largement limitées. Et c'est là où j'interpelle justement les organisations de la société civile, les INDH. Je vais interpeller également un organe africain qui peut jouer un rôle important, il est très intervenant, c'est le Parlement panafricain. Le Parlement panafricain qui effectivement rassemble les représentants des parlements nationaux africains et qui pourrait, à mon avis, jouer un rôle dans la mesure où les lois qui sont discutées au niveau européen sont parfois également des points de thématiques tels que la liberté de réunion, la liberté d'assemblée, d'association, peuvent être discutées au sein du Parlement panafricain, de manière à sensibiliser les parlementaires, notamment, de prendre en charge ces lignes directrices lorsqu'il s'agit soit d'adopter de nouvelles lois, soit de réviser également des lois qui seraient en contradiction même avec les dispositions des conventions. Donc ça, c'est également un point important. Et puis, un des panélistes a évoqué la question de l'ordre public, de la sécurité nationale, des valeurs morales. Là, c'est votre problème, parce que très souvent, on se lève à ce qu'on appelle justement ce triptyque, oui, la liberté d'expression, par exemple, oui, pour la liberté de manifestation, la liberté d'association, mais conformément, notamment, sans toucher à l'ordre public, sans toucher à la sécurité nationale, ou encore ce qu'on a rappelé aussi, les valeurs morales. Or, sur ces trois expressions, l'administration a un pouvoir discrétionnaire. Donc, on ne peut pas dicter à l'administration et dire qu'est-ce qu'on recouvre la notion d'ordre public, elle est très élastique. Qu'est-ce qu'on recouvre la notion de sécurité nationale, elle peut être différente d'un État à un autre. Et c'est, je crois, sur ce point où le juge pourrait jouer un rôle important. Alors, le juge a un rôle important dans la mesure où il peut, à son niveau également, à son niveau dit, développer toute une jurisprudence dans laquelle, lorsqu'on s'aperçoit qu'une loi est contraire, par exemple, ou contraire à des dispositions conventionnelles,
mais la loi est très vague. Et on dit, le juge a la possibilité d'appliquer directement les dispositions constitutionnelles. Nous savons que dans de nombreuses constitutions, dans le cas des pays qui ont au cours de ce que j'appellerais les pays violalistes, dans la priorité des conventions internationales sur les lois internes. Donc, c'est pour dire que dans la mise en œuvre de nos directives, il y a plusieurs pistes à utiliser, il y a plusieurs acteurs à interpeller, il y a plusieurs actions qui pourraient effectivement envoyer une bonne mise en œuvre de lignes directrices sur la liberté d'association et de réunion. Voilà, monsieur le président de séance, je me voulais juste apporter une petite contribution sur les stratégies de mise en œuvre. Merci.
Thank you very much, Madam Vice Chair. Michael Professor Batalon, providing us the opportunities of standing and saying, and the function of the care of the roles of actors, okay, now we'll into the last piece. Thank you very much, Commissioner Dawson and the chairperson. We want to cover the issue of registration, which was, I think, raised by the college for the NGOs, particularly concerning now. To begin with, the chairperson and the in considering view, we feel that registration of NGOs is not impediment to them to exercise, to enjoy and exercise human rights on behalf of the Malians. Rather, it's a mechanism. NGOs are supposed to operate by the rules. And this the reason why even the African Commission cannot grant observer status or accredit an NGO which is not registered in the country. The terms that apply to the African Commission are the ones that also try to adopt in our country. NGOs operate on behalf of Malawians, they handle funds, as such, they're supposed to be eligible to the range of Malawi. If it's for the destiny, we don't see the reason why NGOs wish to operate further. Yet they handle funds on behalf of Malawians, yet they do projects on behalf of Malawians. So the issue of registration, it's not an impediment to the enjoyment of the human rights and the function of the applied. Thank you very much, Chairperson. Thank you. Also includes members of the committee that have the point of Churchison, for the various views that have been expressed in the course of the discussions. So I turn the floor back to the members of the committee.
Thank you, Mr. Chair. There's two, what is going on? One of the key recommendations might be to look at the sensitive documents themselves. I think there's a lot of information within the documents and the accompanying report from the study group, which highlights why there are issues around, why mandatory registration is not the best practice. I think we can go into the exhaustive panel, but when we think of organizations, we always tend to think of the traditional NGOs that are engaging in these types of spaces, but there are smaller community-based organizations, small associations, clubs, all of these organizations then fall under the legislative framework. And I think whenever we draft legislation, we need to think about what can impact on some of the small organizations who may not want to gather a lot of funds from donors or have big programs, but are only benefiting some of their own members within their own community. So the one recommendation that says around sensitization around some of those issues, both association and also assembly. And then the second, I think we see from the aspect of the national human rights institutions and the NGOs that implementation of the challenge. And I think that is where the monitoring and strengthening of monitoring and documentation to be able to take action on those issues is something that could be beneficial across the information side, the state actors, the NGOs, and the others.
Thank you very much. From this discussion, we have looked at issues which the CSOs, the human rights defenders, can do in order to promote and publicize this guidelines and ensure that freedom of association and similarly protected. So the first one speaks to developing and using multiple tools which will be used to measure governance compliance with the public guidelines and also the document and also report the situation of such freedoms internationally and regionally. The other one will be advocacy activities which are geared at promoting these guidelines by seeking review of national legislations in order to comply with the guidelines for greater enjoyment of these rights. The fourth, there was issue of strategic litigations, and maybe CSOs can also decide to do this litigations which are aimed at approaching the rights of freedom of association and assembly. The other one, the last one, is about capacity building. I think CSOs can also assist in providing capacity building on the guidelines to the government agencies as well as members of parliament when they make such laws. Already already exist, maybe we can also have such capacity building in order to review such laws. Thank you. Thank you.
Thank you. I think it has been a very useful business, particularly in terms of states and engagement for the first time in this country, and it is coming with the investment in national human rights institutions. I think it provides an opportunity to do more with this kind of exercises, and also to replicate this study further in Southern Africa and other parts of the African continent. And then also the Commission country projects to begin collecting some of the data that is currently here to assist the state with reforms reforming the legislation. And then it's also inspired by the Deputy Vice Chairperson's suggestion of best practices
that we can implement to each level. States have the opportunity to learn from one another. So introducing best areas and practices in the own countries. I think it's something that we can use. This is Africans providing solutions to own African problems. Thank you very much.
I'm not sure if Hassan is still around. If he wants to have the team is good. Hassan? Okay.
Oui, et je suis en ligne. Alors, juste dire que il appartient aux institutions nationales des droits de l'homme, au regard de tout ce qui vient d'être dit, de s'approprier les lignes directrices en vue d'accompagner au mieux les initiatives gouvernementales pour doter les pays de législation pleine, non équivoque, non confus, ce qui concerne les libertés de réunion et d'association, de vulgariser ces lignes directrices et de mettre en place des mécanismes d'évaluation des lois relatives aux libertés d'association et de réunion et de suivi de mise en œuvre de ces lois dans nos États pour que les lignes directrices soient à tous les temps de l'action de l'État soient prises en compte par les agents sociaux.
Okay, I think about the flight too. It's the fault I did very much to just some You can conceive it. The civic space, you can control the civic space with the mind of the person. The mind of the person is not an education. Then this person will be different. And something is the civic space.
And as far as the African Commission on Human and People's Rights is concerned, yes, we make a distinction between those that come to the Commission requesting observer status
Like I don't say that. The association wanted to those not come to the commission seeking observer status. Freedom of association applies to all views, whether it is a legal or something. And that's the fundamental point of the guidelines, which we find in the guidelines article of the Convention on Human and People's Rights. With that, I wish to once again thank those of you who participated in this panel, but also all of you who have patiently listened when we put on the various insights that have been shared with us this afternoon. I would like now to hand over the floor back to the Vice Chair. Before I do that, kindly join me in thanking the members of the panel. Vice Chair, over to you.
Merci beaucoup, Monsieur le Commissaire Berceau, d'avoir pris en charge la modération de ce panel. Je remercie également, en mon nom et au nom de tous les membres de la commission, les différents panélistes qui sont intervenus. Alors, nous allons donc poursuivre nos travaux avec le point 3. Je pense que les panélistes peuvent rejoindre leur place éventuellement. Le point 3 qui est relatif à la situation des droits de l'homme en Afrique. Oui. On va attendre qu'il se positionne. Merci. Donc, je reviens au point 3 relatif à l'examen de la situation des droits de l'homme et j'ai sur ma liste une demande de prise de parole d'un délégué d'État de l'Afrique du Sud, South Africa, Monsieur Luvuyo Ndimimeni, chef directeur Union africaine. Est-ce qu'il est là? Non? D'accord, je vais repasser en revue la liste de ceux que j'avais appelés ce matin. Alors, en ce qui concerne les organisations internationales, UN Women AU Liaison Office, je pense que c'est Madame Tikikel Alemou. Est-ce qu'elle est avec nous? Et toi, oui, on va attendre un petit peu. Vérifier si Madame, je pense, et Monsieur? Non, elle n'est pas avec nous. D'accord. Alors, je passe aux institutions nationales des droits de l'homme. CNDH Mali. CNDH du Mali. Non. Alors, nous avons également la Commission des droits de l'homme et de la bonne gouvernance de la Tanzanie. Vérifier, non. La Commission nationale des droits de l'homme du Kenya. Non. La Commission nationale des droits de l'homme de Côte d'Ivoire. Non. D'accord. Commission nationale des droits de l'homme du Togo. Non. Alors, pour les organisations de la société civile, nous avons deux demandes, enfin, en tous les cas, une qui est venue s'ajouter cet après-midi. Tout d'abord, je vais appeler Environnement, ressources naturelles et développement. Monsieur Bantu Baloudje, virtuellement, non? Et nous avons enfin le représentant d'Open Society Initiative of South Africa, OSISA, Monsieur Amir Suleiman, en présentiel. Aujourd'hui, il est là. Il est présent sans être présent. Non, d'accord, très bien. Et bien voilà, donc j'ai dû rappeler les différents acteurs qui étaient inscrits sur la liste concernant l'examen de la situation des droits de l'homme en Afrique. Puisqu'il n'y a pas de prise de parole, nous allons clôturer la journée d'aujourd'hui. Mais avant, je vais passer la parole à la représentante du secrétariat pour nous édifier sur l'agenda de demain et s'il y a effectivement d'autres informations. Merci.
Thank you, Vice Chair. For tomorrow's agenda, Tuesday, 9th of May, 2023, we will start with agenda item 5, activity reports of the members of the Commission and special mechanisms. We will have the activity report of the chairperson of the Working Group on Extractive Industries, Environment and Human Rights Violations in Africa. This would be followed by the tea break, and then we will have item 3, the human rights situation in Africa, and also item 6, panels and launches. We will have a panel of awareness in support of the Treaty Against Trade of Instruments of Torture. This will be followed by the lunch break. Then we will continue with item 6. We will have a panel on the 29th commemoration of the 1994 genocide against the Tutsi in Rwanda. We will also have another panel on human rights situation in prisons in Africa. And this would be followed by the last item, which would be item 3, human rights situation in Africa, to the end of the day. Thank you.
Merci beaucoup, Madame Aminata. Et bien, c'est donc sur ces dernières paroles que nous clôturons la journée d'aujourd'hui. Je vous souhaite une très bonne soirée et à demain. Merci. Et vous avez bien sûr la pause café qui vous attend. Même endroit. Oui, dans les mêmes lieux où la pause café a l'habitude de se dérouler. Merci beaucoup.